about a half an hour late.
Who's going to be a half hour late?
Bob, Jubinville.
So you're not going to wait a half an hour.
No, I'm not. But also Terry Kennedy is going to be on WebEx. And
You know something? We have 10 o'clock. We have a break at 12. I would like to eat something so I won't faint before 4 o'clock when we're through with the second.
okay,
So I think we don't accommodate people because they're in court. We have a responsibility on our website. We say 10, we say 1, and I'm not going to delay mine any longer. I waited till 1:22 last time, Mary, but
Okay.
I mean, they came in at
All right.
1:22. That's wrong, okay?
okay. All right, so
It's 10 o'clock.
Would you like him brought in now, everyone?
yes.
Okay.
Good morning. We need masks. Good morning. Can you hear me?
You can all sit down.
Yes.
Okay. So Counselor Jubinville is going to be here, but he's going to be a little late. Counselor Kennedy is going to be on WebEx. And where the rest of the cherubs are, I'm not quite sure. However, we said we'd start at 10 o'clock. So we're going to start at 10 o'clock. So I'd like to introduce Counselor Marilyn Pettito Devaney, who is here with us. And I'll introduce the other counselors afterwards. We have one witness, Elizabeth Morse.
Excuse me, you have Counselor Paul. Paul's,
Counselor DePalo is there.
yes.
Thank you. I'd like to introduce Counselor DePalo. And he's the counselor from the district next to mine, Worcester County, etc. And so at this time, I would like to ask that all of your other witnesses there as well.
Yes, Counselor.
Thank you. All right, I'd like you and the other counselor, or the other witnesses, excuse me, to stand and be sworn in. I hereby promise to tell the truth and nothing but the truth as it relates to the matter now before the council in the hearing of James Manitsas as an appointee to the Superior Court, nominee to the Superior Court at this point. You may be seated.
I do.
So swear.
We're going to call on Superior Court Justice and Regional Administrative Judge for all of Hampton, actually all of Western Mass, all the counties in Western Mass. Michael, you want to start?
Yes, thank you, Councilor Hurley. Good morning, everyone. My name is Michael Callan. I'm an Associate Justice of the Superior Court. I want to take this opportunity to thank members of this council for the confidence that you had in me a little over 5 years ago. I'd also thank you all for the colleagues that you sent us over that time frame. We all owe a debt of gratitude to the governor's office and this council for the hard work that you've done to strengthen and diversify our judiciary. I appear today with some brief thoughts for you as you consider and deliberate upon the nomination of Attorney James Manitsas to the Superior Court. I just want to say, first of all, that I'm thrilled with the nomination. I've known Jim at least 25 years, both as a lawyer. I've tried cases with Jim. I've tried cases against Jim. I've had Jim try cases in front of me. I believe, based upon that period of time and my understanding of Mr. Manitsas, he's well suited and qualified for this position and will make an excellent justice of the Superior Court. Jim has an excellent reputation among the judges, but more importantly, he has an excellent reputation with the staff, the clerks, the court officers, and everybody that works in the court system. I think he's demonstrated a remarkable resilience over the course of his career in trying a great number and varied types of cases. I think that active listening is a skill most suited to be a judge, either in the Superior Court or otherwise. In my perspective now, after 5 years on the bench, Mr. Manitsas is an excellent listener. Equally important is his ability to be patient. As I said, I've known him for a very long time, and I've never observed or even heard of Jim being impatient or short with anybody. I think that we've tried cases together with very high stakes, with significant consequences to our respective clients, and with cases that had a full range of raw emotions. And in those cases, in my mind, it's easy to be calm and cool and collected when the going's easy and things are calm, but it's totally a different thing when you have high stakes, raw emotions, and close moments. Even in those instances, I've known Attorney Manitsas to be unfailingly calm and deliberate, even when facing those extraordinary moments. These are qualities that I think are essential for a judge, and I believe that these qualities will lend themselves well to Attorney Manitsas's qualifications to be a Superior Court judge. So, in closing, I want to be brief. I've just had a few years on the Superior Court. One of the more challenging and surprising aspects of this job is how information comes at you imperfectly at times, quickly, imperfectly, not in an organized way, but on the fly. And I believe that Attorney Manitsas possesses the skill and the temperament to listen to these varying viewpoints, distill the arguments, identify the strengths and weaknesses of any case, and apply the law with a sense of empathy, fairness, and compassion. So if this council deemed fit to confirm it to the court, I am confident that he will be a great asset to our court for many, many years to come. Thank you very much.
Any questions?
You're going to,
Councilor Devaney?
welcome back.
Good to see you again.
I was thinking half of your term that you've been in the Superior Court has been in the pandemic.
Yes.
Tell me how it changed.
Well, I think that's a great question. I do want to take this opportunity to commend the judges and the staff and the court officers and everybody, the lawyers, and especially the jurors, come in now in the last 6 or 8 months to try these cases. It takes a tremendous amount of courage for people to do that in the midst of a pandemic. And it really has been awesome to see the public showing up, doing their duty as jurors and citizens and trying these cases for folks that have waited.
So the nominee will be, if he is appointed, he'll be on the bench when things are back to normal.
Hopefully, none of us can certainly predict the future, but
But as it is now.
we're moving back toward a more normal process of cases being filed and disposed of in a timely fashion. Yes.
So how long have you heard this nominee that he's coming?
At least the mid-90s. I met him in the mid-90s. I think when he came to Springfield in 96 or 97, we started having cases together.
Yeah, great. That means a lot because, I've said it before, we've had someone come as a witness and I've said, you know, how you know this nominee. Oh, I saw him once in court. So that's pretty good. That's,
Yeah, 25-ish, 26 years, certainly. I mean, there are cases that we had together that, 25 years ago, like I say.
so what, is there any case that was before that he came, that you,
As a lawyer, he tried one case before me, probably 2019. So he did a wonderful job. It was a very difficult lawyer on the other side, some relatively high stakes, but he was very calm and did a wonderful job. And I was impressed with him, as I expected to be. I have no question about him that way.
it's nice to see you. I think
you.
it's the First time, is it?
I voted for Jackie Cowan.
Oh, that's right here.
That was good. Yeah.
It's good to see you and thank you for hearing, because, you know, a lot of the people in court are working at home, and so we appreciate your going in every day, because that makes it easier for the staff too.
Right.
Because the one judge said to me, no, I'll be there every day, because I don't want that they have to email and send back and forth and all of that, so being there means a lot.
I mean, we view ourselves as serving the public, so whatever the public needs in terms of us either being there or being remotely, we're willing to do.
Knowledge of this nominee means a lot to me, so I really appreciate it.
Thank you very much, Council.
Any other questions, Counselor DePalo?
No questions.
All right, thank you very much for your testimony and for all.
Counselor Hurley?
Oh.
Yes.
Counselor Jubinville is with us now.
Thank you. Good to see you, Judge.
Good morning, Councilman.
Springfield.
Moving right along.
Running a great show out there. You
Thank you
get
very much.
compliments. You really do.
Thank you. Hard work.
A bunch of your colleagues are a breath of fresh air in Springfield.
Thank you. I'm proud of everyone out there, the clerks, the court officers, judges, everyone's working hard to make sure that we do our jobs to the public.
You're doing it. You're doing it.
Thank you.
I have one concern about this nominee. He has no criminal experience.
Not at all. Well, I think that he has the intellectual ability and the temperament to learn the criminal law. I know that he'll be patient about learning it, but there's really three things I want to emphasize about that with respect to the criminal law. First, the Superior Court under Chief Brieger's continued Judge Fabricant's mentor system, where she assigns a mentor to each new judge for 2 years. And that mentor works very closely with any judge, whether they come from a criminal or civil background, to educate the judge and be a sounding board and resource to the nominee. Second, Chief Brieger's continued the robust educational aspect of the job. We have educational seminars, conferences, live and remote, cover a wide variety of topics. There's great written material that we all have access to. And really, that's where I leaned on heavily, in addition to my mentor, who's Dick Kerry from Northampton. And by the way, I still call Dick Kerry with questions, which leads me to my last point, which is there's 70 or a little more colleagues on the court. Every single one of them is always available to me and any other judge to talk things over, to get a perspective, to have a full conversation about what the issues are, whether it be an issue during the trial, or what have you. So I'm confident with the support of our colleagues, and with him taking advantage of the educational opportunities, he'll be up to speed in due course on the criminal end. And on top of that, Counselor Jubinville, he's a humble guy, and I think it takes some humility coming into this job, understanding what you know and what you don't know, and being willing to educate yourself on what you don't know. And I know that he'll do that.
You think Judge Flannery and Judge McDonough are going to help him with it? So,
Sure they will. In fact, I'm probably letting the cat out of the bag, but one of the witnesses here was a juror on a trial with Judge Flannery last summer.
kidding.
The Woodcock here. And so, and he may have some comments about that if you ask him, but I think that they'll both be more than willing to help out. And they're both thrilled. Judge McDonough and Judge Flannery are both thrilled with the nomination of Mr. Manitsas.
Judge Kerry retired.
Not yet.
Sometime by the end of next year, I think.
Jurist. That decision he wrote in the drug scandal. I've never seen anything like it in 43 years practicing criminal.
Seeing something like that took a lot of courage. you know, and that's inspiring to me and everybody else when a judge does something like that.
Great to see you.
See you.
Come back and get with us with the council.
Thank you.
Counselor,
Judge Callan, correct me if I'm wrong, but I believe that when you took the bench, you didn't have any criminal background either.
That's right. I had about the same amount of criminal background as Attorney Manitsas. I had civil cases that touched upon the criminal law, but I had no direct personal involvement with criminal cases. And I told Attorney Manitsas on the drive down here this morning that what I did when I got assigned to a criminal session, one of the very first things I did when the lawyers came in and started arguing, I said, because I wanted to be humble about things and I wanted to be straight with people, I said, look, everybody in this courthouse knows I don't have any criminal background, so take this and proceed on a basic level and educate me on this. And the lawyers seemed kind of shocked that I said that, but I got feedback later from the bar that everybody appreciated that I wasn't taking the bench with any arrogance, and I was humble enough to say, help me out here, walk me through this. And I know that if I'm given the opportunity with Jim to give him that advice, I'm sure he'll take it. Just be humble.
criminal experience, but you got a lot of other wonderful qualities.
Thank you very much.
Also, Judge Callan, correct me if I'm wrong, but I believe that you and the nominee have worked on cases that involved a criminal and civil aspect to it.
Yes. One in particular comes to mind. It was a case involving a motor vehicle, a pedestrian death, that we both had aspects of that particular case. We worked together, and there was certainly a criminal aspect of that, which we were intertwined with the DA's office and the defense bar in terms of getting both the civil and the criminal case to disposition, which it did. Thank you.
All right. Any other questions? Any other new arrivals? Eileen,
Counselor
Duff is here.
Thank you, Madam Chair. I had a wonderful talk with Attorney, and I really don't have questions, but I really don't have any questions. I think you're eminently qualified for this position. I think it's going to be a great fit.
All set, Counselor Hurley?
Yes, Counselor Kennedy will be there in person in about 15 minutes. I'll see if he's got any questions of you, but we're going on from here. And I'd now like to call on Elizabeth Morse, who is with us on WebEx. So you may proceed.
Thank you. Thank you, Madam Chair and Councilor Hurley. I am so pleased to be here. I'm sorry, I'm just adjusting my camera a little bit. So pleased to be here this morning. I'm sitting in my office on Main Street in Worcester, where I have practiced for about 33 years. And just by way of background, I am a trial lawyer. I practice primarily in the district courts and the superior courts. And up until a few years ago, I traveled very frequently to Springfield, probably about twice a week, where a lot of my business was at that time. And over the many years that I did travel to Springfield, I had the great pleasure of meeting Attorney James Manitsas and having many, many cases with him. When Mr. Manitsas called me and asked me if I would testify today, I was so pleased. And I went back, just did a very brief search in my computer records, and I thought I found about 15 cases that I had with him over the many years since about the early to mid 2000s. And I want to tell the council that most of the cases that I had with Mr. Manitsas, he was actually on the plaintiff's side of the case, which is a little bit unusual given his resume. The types of cases were all personal injury cases, but they varied with the types of clients that he had. And I was always very impressed with the manner in which he handled his clients. Many of those clients were not particularly of wealthy means. And I remember one in particular that the young woman had suffered from mental health problems. And I was so impressed with the way he handled her in a compassionate way, but managed to get through her legal problems, and we got them resolved eventually through arbitration. But I was so impressed with the way he handled that situation, because it showed a great depth of person. And I came from working in a mental health background before I went to law school. And so I've always thought that that was so important for us lawyers, and certainly the judges that sit on the bench, to have that understanding and compassion for people who may be coming from different life situations. I also want to tell the council that I did serve on the JNC for 8 years. And so I have a very personal stake in helping you to make sure that we get quality people on the Superior Court and all of the other courts. And I think that this particular appointment hits it on the mark. We want to have people who are willing to learn. We want to have people who are compassionate, people who show good judgment, and particularly on the Superior Court, which is, of course, all the courts work hard. Superior Court has a very diverse number of topics that it deals with. You have to have someone who can think fast on their feet and be willing to learn. And I've always found Attorney Manitsas to be that type of person. If you look at his practice, he's not only doing just personal injury defense work. He's represented plaintiffs. He volunteers at the probate court, lawyer for a day, which is actually quite unusual for insurance defense people, because that's a whole different aspect of the law. He's always been interested in working on some matters in the housing court, helping people out with their housing issues. So I think in summary, basically, Attorney Manitsas really does have all of those qualities that we want as citizens of the Commonwealth, to have in the person that we place in such a position on the bench, that is, this person is making such important decisions for all of us, and essentially we're relying on the good demeanor, the good judgment of the people that we put on the bench. I think Attorney Manitsas is a terrific nomination, and I really wholeheartedly support his nomination and hope you move him forward. Thank you.
Thank you. Are there any questions of Attorney Morse? Anybody? All right, hearing none. Thank you very much for your testimony.
Thank you.
At this time, I would also like to introduce to the participants who are here, Chief Justice of the Superior Court, Heidi Brieger. Thank you for coming. And I assume that you're here in support of nominee Manitsas' nomination.
Councilor Hurley, I'm here in enthusiastic support. I haven't known Attorney Manitsas very long, but I have done some due diligence, and I hear nothing but glowing reports about his competence and his demeanor and his willingness to serve the Commonwealth. So I'm delighted to support him today.
Thank you very much. And now we're going to hear from a lifelong friend of Attorney Manitsas, Jason Woodcock. You've been friends since first grade?
Not quite lifelong, but the lives of our daughters, I guess we can say.
Okay, very good.
So yes, hi, my name is Jason Woodcock. I'm a high school teacher in Belchertown, where Jim and his family live. I've known Jim since 1999. We met when our daughters and Jim's daughter, Samantha's right over here. Samantha and my daughter, Sarah, became friends in 1999. They met at a dance studio, and sort of as their friendship blossomed throughout their lives, ours did. We spent lots of time together. Dance events, as our daughters would socialize with each other. Our daughters were both athletes and were very much into softball. Jim and I coached their youth softball team for many years. Jim even had the idea, girls were sixth grade probably, to start a traveling team that he and I coached. Jim did all the legwork on it. And as our daughters went through high school, they remained good friends. We remained good friends. And then our daughters graduated and went off to different colleges, and their lives moved in different directions, as happens. But Jim and I remained good friends. I'm very, lucky to say that Jim is one of my closest friends. And in all the time that I have known Jim, he has been nothing short of, a man of great integrity, compassion, character. To echo what Judge Callan said, patience, that's a very, very good word to describe Jim. To coach youth softball, you have to be patient, I guess. Anyone that has seen or been part of that would know that for sure. Just Jim's ability to deal with, in my experiences with him, to deal with children as they age to high school students, to deal with their parents, to deal with any number of different people. He has just always represented himself in a way that I guess I wish I represent myself. Just a man of great humility and integrity and patience. Again, an excellent word to use. I mentioned that I'm a teacher. I actually teach high school history and government. And as I teach government, really my weakest area would be the inner workings of the judicial system. And I have been able to rely upon Jim's advice and wisdom there many, many times. Just a quick phone call or a text, hey, I got a question about this, or a student had a question about this that I don't necessarily know the exact answer to. And he was always very, very, not only willing, but in a very concise and excellent manner, gave me an answer that I could give to my students. So his willingness to be of sort of indirect educational value to the students in Belchertown it's been going on for decades, really, and I appreciate that. But I just
Thank you
want to
very
say,
much. Any questions of this witness,
I have one.
Counselor Jubinville?
22 years.
You ever see him get upset?
No, that's the most amazing thing as
I mean, in 22 years, you're a close friend. Never once have you seen him get upset.
well, I mean, upset in what context? I mean,
Context.
upset maybe, we would go on family get-togethers and, maybe my dad or something, but he was always calm, always. You could see that it's like, okay, well, I'm not particularly happy that this happened, children do things, but he remained, his demeanor, this is Jim at all times. He just has this very calm, composed demeanor, and he thinks things through very well before he reacts. Clearly never overreacts. That is a trait of his that I admire. But it is the God's honest truth to say that I have not seen Jim get angry. I've seen Jim hit many a errant golf shot that would make me very angry. It makes me angry when I'm hitting it this way, but no, he's just always a man of composure.
Even Jesus got upset now and then.
I know this maybe sounds like I'm being not truthful, but it is the truth. Jim is all the time.
Well, I bet everybody in this room has.
spend some time with Jim and you would be amazed at his just composure. And I think, and I know nothing of the system that Judge Callan spoke about, but these are the qualities that will make Jim an excellent judge. And as mentioned to you when you first arrived, I served on a 6-day jury trial this summer with Judge Flannery, and he was excellent, by the way, phenomenal. So getting to watch, first time in my life I've been impaneled on a jury, getting to watch the process and focusing on the judge as a teacher of government, I was trying to pay people attention to these things.
Was it a criminal or civil case?
A criminal case, in a criminal case
With jury vote?
there were 14 indictments, guilty on maybe just short of half of them. It was a horrible crime. It was just something
Jury out.
8 hours. And the judge was excellent. And in watching the way that all sort of unfolded, Jim will be excellent also at just his composure, his sort of commanding presence in an understated way will enable him to command a courtroom.
Where have you been teaching?
I've been teaching for 28 years.
Belchertown?
Yeah, well, I taught at Maha Regional in Orange for 4 years and Belchertown for 24.
Thank you.
Oh, you're welcome.
Thank you very much. And also, Counselor Devaney?
Thank you. Someone that's normal attorney, personal basis. So you've seen him, at games, and there's been times I'm a parent of 4 children, and he's not happy with some of the the judgment game or whatever, and you observe him all these years. That means a lot to him. Now, was that murder case? Was that Judge Mason?
It wasn't a murder case. It was Judge Flannery. It was a case of aggravated sexual assault and abuse.
Okay, yeah, right. No, no, thank you for coming.
Oh, you're welcome.
Personal, testimony. Thank you so much.
You're welcome.
Also, Counselor Ferriera has joined us on Zoom or WebEx. Do you have any questions, Counselor Ferriera?
I do not have any questions. We had a nice conversation, and I have to say that Counselor Hurley is a huge fan, and that means a whole lot to me. With her being a judge for 20 years and living out in the western part of the state, I think you're going to make an excellent judge in the Superior Court, and you have my support.
Thank you. All right.
Thank you.
That concludes the witnesses, and
Thank you.
I would ask at this time, is there anyone who wishes to speak in opposition to the nomination of Attorney Manitsas? Hearing none, that portion of the hearing is closed, and I would now invite Attorney Manitsas to introduce his family. I think everybody else has been there and spoken, and you can give your opening statement. Thank you.
Thank you. Good morning, everyone. I first of all want to thank Governor Charles Baker and Lieutenant Governor Kerry Polito for my nomination. I'm humbled by the confidence they have placed in me by nominating me for a position on the Superior Court. I'd also like to thank the JNC, Lauren Green Petrino, Bob Ross, and the Joint Bar Committee. Finally, I want to thank Governor's Council, Council Mary Hurley for our support and assistance, and every one of the counselors for taking the time to review. I also want to take this time to really thank Superior Court counsel for being here today, Attorney Elizabeth Morse, agreeing to testify on my behalf by WebEx, and again, thank Jason Woodcock for his kind words and agreeing to be here on my behalf today. I also have to thank my family, my wonderful wife and partner for 29 years, Megan, without whom I wouldn't be here today. And my daughter, Samantha. Sorry. My 27-year-old daughter, Samantha, who I am so proud of for everything she's accomplished so far in her life, and for what I am so excited to see happens to her moving forward. Lastly, I want to thank my 93-year-old mother, Manitsas, who has been an inspiration to me throughout my life. Counselors, I'm the fourth and youngest child of Demetrius and Mary Manitsas. My father was a high school guidance counselor. My mother was a registered nurse. And I grew up as a fairly typical middle-class kid from a small town in Western Massachusetts. My life took a profound change when I was in high school. During my sophomore year, my mother suffered a work injury that put her out of work and required her to undergo a fairly substantial surgery. And that injury essentially left her incapable of ever going back to work as a hospital nurse. To make matters more complicated, during the summer before my senior year of high school, while my mother was recuperating, my father had his first of a series of heart attacks that led to his passing about a month before I graduated from high school. So in May of 1984, my then 56-year-old mother was now a widow, a daughter in college, and had a son set to go off to UMass in the fall. And she was faced with all of this with the realization that she was never going to go back to work in the only career she had known. And I watched my mother as she reinvented herself in the nursing field, made sure my sister completed her college education, got me off too, and made sure I got through my undergraduate career at UMass. My mother's determination and perseverance taught me when you get knocked down, you get up and you move forward in a positive way. It taught me the importance of hard work, and it demonstrated the sacrifices one makes to help others around them. I graduated from UMass in 1988 with a degree in legal studies. The pursuit of the law was not my purview when I entered college. In fact, I started out as an engineering student, and there were no lawyers anywhere in my family tree. Grandfathers were printers and plumbers, and I took a rather circuitous route for the study of law. But ultimately, my interest in the law was piqued when I did an internship my senior year of college with the Legal Services Office, where I worked on tenant housing issues. After college, I went to work to save money for law school. I was a social worker, working in Holyoke with homeless families who were placed in hotels and seeking to transition them to a more stable and secure living environment. I then went to the Quinnipiac University School of Law, where I graduated in the spring of '92 and was admitted to the bar that same year. I began my legal career in private practice, representing tenants in housing disputes, serving as a bar advocate in the Holyoke District Court, and handling defendants' post-conviction appeals through CPCS. About a year and a half later, my wife and I learned we were expecting our daughter. Wanting and needing a more stable situation, I took a job as staff counsel with the Century Insurance Company. And there I came to work with my now eventual law partner, Tom Murphy. Tom had been a prosecutor for over 10 years before he stepped into the role of managing a staff counsel office. And over the next 3 years, under his guidance, I tried more than 24 motor vehicle cases in the district courts from Worcester County to the Berkshires. 1997, I left the staff counsel office and went to a firm representing plaintiffs in all forms of personal injury cases in both the district and superior court. And over the next 7 years, I tried probably more than 30 jury trials. In 2004, Tom Murphy and I reunited to start a private practice. And for the past 17 years, I've been involved in handling complex litigation, wrongful death cases, dram shop cases, construction, real estate, insurance coverage issues, indemnification issues. And while my practice is primarily on the defense side of these cases, I still represent plaintiffs, and I occasionally assist clients in criminal matters. So what brings me here today to ask for your confirmation of my nomination? I've been very fortunate in my career. It has been both personally and professionally rewarding. And this has led me to want to give back to both the profession and the community as a whole. And I now know that I am ready for a new chapter and a new challenge in my career. 28 years of practicing law, with the last 15 primarily being in the Superior Court, has taught me that working with a good judge can make all the difference for the parties in any case. I am ready to step into this role in Superior Court, and should this council agree to confirm my nomination, I pledge to work diligently, to exercise patience, to always be respectful, and above all else, to be fair and equitable to every person and party who appears before me, regardless of race, class, religion, gender, sexual orientation, or the like. I'd just like to again thank this council for giving me the opportunity to come here today and speak with you. Thank you.
Thank you very much. I'd also like to introduce Counselor Christopher Iannella, who's the Dean of the Governor's Council. Does anyone have any questions of the nominee? Counselor
Not to.
Iannella?
Thank you.
Oh, so good.
Now, work for the bar.
Yes.
I used to see him. I was in Boston. Just always advertised.
He is.
No, the reason I said,
This
a lot,
competition.
no, I do personally. And a lot of people come and go when it comes to advertising. But the biggest advertiser on the mall, 25 million years. Now, Social Security, they went back to security. You know,
He is still around. Actually, his office, the office I worked at, is around the corner from my office. And in fact, his office on occasion has referred me cases to handle in litigation. It's primarily to the western part of the state. Yeah. Yes.
But you do.
I do a little criminal work, you know, I'll tell you, most of my cases, the last I had, big example, was one of the executives from an insurance company I do work with, was a flight attendant, got into a altercation with a coworker at Bradley International Airport and was charged. I'm admitted both in Massachusetts and Connecticut. I went down to Enfield Superior Court and assisted her through moving the case to what they have. It's called accelerated rehabilitation, the pre-arraignment disposition, sort of similar to our 276-87, and helped her out in that fashion. So I still do some criminal. My office does a fair amount, and my partner was a prosecutor for 10 years. He does a fair amount of OUI defense, so I see that matters in our office. I have never tried a case in a criminal case.
Your criminal experience.
It is.
You've done a lot of litigation.
Yeah.
What position on summary judgment motion? Most of the summary judgment motion.
I mean, I think the standard is pretty clear. If there is a material issue of fact, then the motion should be denied and the case should go to the jury. If it is a situation where there is not a material issue of fact, then likely that motion should be allowed. In the context of negligence, negligence is a factual heavy analysis, so that more often than not, those motions are denied because the determination of fault is one of facts and law. You really can't separate those two. And And the jury's really in the best position to determine what a reasonable person standard is.
And most people that I asked what you said,
I would agree with that.
Counsel Ionella, I'm having trouble hearing you. Could you get closer to your microphone, please?
We don't have. I'll do a better job to speak up.
Thank you.
Sorry. Continuance. What's your viewpoint?
Generally, within some bounds, I would favor deciding cases on their merits than forcing a case forward that's not ready to be tried.
I mean that, I'm sorry. I mean, oh, I get you.
Generally open to allowing the lawyers to try and to get their cases ready.
When would you be opposed?
I guess my concern would be if there was a pattern. If it became apparent that, you know, someone was looking to push something off and continually pushing something off and off, then it might become a point where keep the process moving forward.
And why do you take care of this continue 10, 12 kids?
Well, I think we care because we want cases resolved. I think everyone. I think.
That question. What's
In general, I think the parties to matter, the court, the society wants disputes resolved. So again, generally, I would have no problem with a continuance unless I felt it was becoming too, you know, if we're 5, 6 times, then it might be an issue.
this? I don't think anyone cares if my personal history on the case maybe. No. And I don't want to put words. The reason I asked this question is a lot of. I won't go to court. Okay. I know a lot of people, just take this look at this. They're gonna pay the rent. They're gonna pay the electric bill, gas. Maybe they have a paralegal. They do what's it's court. I think. Yeah.
4 lawyers.
Oh, boy, that's one thing now. That one way. That one way. If you. There's a lot of those people out there.
I have no problem, would have no problem granting a continuance for someone for those situations. We've all been in situations where I've got a conflict. If you've got another matter, I always, in my practice, if someone calls me up and says, I've got to be at a deposition or I got called in and I'm starting a trial tomorrow, I have no problem whatsoever to granting a continuance to an attorney or to a party if there is some issue that makes it difficult. Nor do I have a problem with, continuing something if someone's like, I've got to be in Worcester and then in another court. Those are all things my position's always been in my practice, to let the lawyers lawyer. And I would not in any way stand it.
Talking about where it's not even, it's not an assented motion. That's can't because
I'm okay with that.
what about a situation where there's a jury trial and one of the but we got this new variant coming. I'm nervous as hell. I know what time. Sure. People things like that, increase, spiking. Ways the client doesn't come. Other type of case, doesn't feel you notice. She said, I'll look to Mr. Colby. That's the truth.
I would be very respectful of people's concerns, especially around what we've been dealing with for the past 2 years. I don't feel that I would compel anyone to go forward if there's a safety concern, a legitimate safety concern that they're having over the situation. I think we've seen over the past 2 years in this situation that everyone has different feelings about the situation. Some people are more comfortable, some are less comfortable. But I think we have to respect those feelings that all people have, and I would handle that accordingly. So if someone had a legitimate concern, health reasons why, they may say, I've got my elderly parents at home, or who knows what the situation is. But I would be very receptive to that.
Well, thank you. What are the other? The trial by Zoom.
I guess the parties were agreeable to.
Oh, that's easy.
If the parties were not agreeable, I wouldn't force someone to proceed in that fashion. We've used Zoom. I've used Zoom. I'm sure your office has used Zoom. It's a great tool, but it's not a replacement for. Yeah.
So do I take if witness no. Anything else? Most of my questions, when I don't.
Counselor Hurley,
Counselor Jubinville.
thank you. Thank you for, I enjoyed listening to your presentation.
Thank you.
Good morning. Have you had the booster shot? Had all the shots? But what if you're in the courtroom and a lawyer comes in, one of the lawyers comes in and, no, I don't want the shot. I'm not getting the shot. How do you handle that? A lawyer on the other side is saying, whoa, time out. I don't want to be in the same room with this guy. And when you're doing a case or a trial, your voice is carrying, and whatever's in that air that you expend is carrying, right? How would you handle that?
If council had a concern about that and didn't feel comfortable with going forward, I would entertain that concern, and if we couldn't address the situation satisfactorily, then we may have to move that matter. That's a
Why would you as a judge want to be in the same room with somebody who hasn't been vaccinated?
we may be
You've got a family you're going home to too.
we may be sitting here today, I think in society right now, in this room with someone who may not be vaccinated. We don't know. But we don't know.
Know whether they're all vaccinated in this room. They may say they're vaccinated and not be. I checked all the cards yet.
Well, I think I would be mindful of, for myself, that I'd be comfortable proceeding, I would be comfortable. That's a personal choice that I would make. But if others involved in the litigation were not comfortable, for example, if a witness was saying, I don't want to be have a cross-examination of myself by someone who's not vaccinated, I would be receptive to that concern, and deal with that and address it.
Because all state employees have to be vaccinated. Right? So why wouldn't all lawyers that come into the courthouse be vaccinated? Right, unless you're vaccinated. Wouldn't that make sense?
It's that's a call for someone else to make.
Not ready to make that yet.
It's
You're
not,
on a road pretty soon. You're gonna have to make a call like that.
I don't know that would be the call of the judge. Whatever
You feel if you let a trial go on and one of the lawyers says, hey, I don't think lawyer Jones is vaccinated and I'm concerned with that. But you say, okay, we're gonna go forward here. And that lawyer or somebody else, a clerk, or even you or your family members get COVID from that lawyer that wasn't vaccinated. How would you feel about that?
I would feel, I would hate to be that situation happen that somebody was exposed because of that situation. I've been in that situation. Supposed to start a trial a couple months ago, and the attorney on the other side said, I'm not comfortable going into court. I assented to the motion to move the trial. I'm very receptive to other people's concerns on that subject. I think going through this for the past 2 years, although myself, I feel comfortable with where the situation is, what I've experienced and seen is that other people's fears and concerns are their fears and concerns, and they're real. And so, although we may have a feeling, we have to accept their feelings on the same subject. They may be different than our feelings, but we need to accept those and handle the situation fairly for everyone involved.
We have, as you know, probably we have a strain on the corona, I guess it's called. We don't know whether somebody in this room has picked that up. And we don't know whether these shots take care of them yet.
We don't. And the situation has maybe opened our eyes to, we don't know what's going to come down the road. Anything. All we can do is deal with the situation as they come with the litigants that are before us.
Fair enough. Speaking of Zoom, I noticed in some courts that I've gone to recently that I've been told, oh, no Zoom, you got to be there in person. And I said, well, geez, I thought, at least I was told by some of the higher ups in the system that Zoom, like you say, is a great tool for certain things. And one of them is pretrial conferences, status conferences, things that don't require evidentiary issues. Why wouldn't we continue to do those on Zoom? I mean, I love going to courts, so I go every day if I can. Just me. I've been doing it 43 years. I love it. Somebody I represent has a job. Over the years, how many of people lost a day's pay for going into a court an hour later, getting a new date and going home and losing a day's pay. So would you have any objection to continuing the Zoom for certain types of proceedings?
No, I,
Better for you too in the court, people that might be infected.
again, as I said, I think it's a great tool. I think we've learned things through this process, and I think some of those things we learned, we should continue to take with us even after, hopefully we move past this.
I had a Zoom hearing, it was a dangerousness hearing. And although I objected, we went forward and parties were on Zoom. DA was on Zoom, the police officer was on Zoom. So I was watching them, I didn't in court. When I was watching them, the police officer is asked questions and he's answering them, but every time he looks down here. Looks down and obviously his police report, I'm assuming. Which you're not allowed to do in the courtroom. And the DA would ask a question and then he'd look above the camera. Somebody clearly was either giving him hand signals or writing on a whiteboard or something, helping him with regard to the questioning. So I think that was terribly unfair to do something like that. So would you have hearings, any kind of hearings on Zoom that required testimony from live witnesses?
I would prefer, I would say no. I would expect, I don't know that you can truly judge the credibility of a witness without seeing them and being there in their presence. There is something that is gained from that process, whether it's body language, what that is an invaluable tool.
Well, in our DNA, we learned to look at people's faces and their body language for a whole lot of reasons. If we feel in fear, we see somebody with an expression on their face that they don't like us. But it's the way we read people, their facial movements, how they move their mouth, how they move the eyes you can see anyway with the mask. But a lot of those facial expressions, we've developed a sense of making judgments about people, the way they respond. And you as a judge, I mean, you clearly, if somebody's wearing a mask, you can't judge what their facial expressions are to any great extent.
That my experiences since this, witnesses are testifying without a mask. And I would allow a witness to testify without a mask. All the courts that I have been in have had or installed sort of plexiglass around or dealing with the witness stands.
Okay, we spoke about Judge Kerry. Did you read Judge Kerry's decision on the drug scandal out in Western Mass?
Didn't read his decision. I saw some of the news about that.
I would suggest you read that.
Well,
because in 43 years, I've never seen a judge write a decision like that. I think it was about 120 pages. And the statements he makes about the prosecutors lying to the court, false documents to the court, and called them out on it. I think it took a lot of guts to do that. You know anything about the drug scandal, I think?
From what I've seen in the news, didn't follow it that closely.
So I guess the question is, and it's somewhat hard for you to answer because you're not in that position, but let's say you were in that position. Would you have the fortitude to write a decision like that? Call out prosecutors, if it was defense lawyers, fine, defense lawyers too. But to put it in writing, tenacity to do it.
If I felt, and knowing, being before Judge Kerry, I suspect he was resolute in his conviction on that subject. If I was that belief, then yes, I would make that call.
Attorney generals that handled the case, two of them that were going to the court, and higher ups, I guess, were involved also. They caused a significant amount of people sitting in jail cells, pretty significant amount of time because of what they did. I think should happen to somebody that is an officer of the court that does something like that, that causes people to spend time in jail because they lied to the court.
Officers of the court are not above the law, and to the extent that they have violated the law, it should be. Likewise, if they are members of the bar, that should be pursued.
Well, my feeling, you lie to a court, and because of that, a citizen of this Commonwealth is incarcerated. You should have to do the amount of time in jail that that person had to do. They're in jail because of the way you lied as a prosecutor. You should be in jail for that time yourself. That's my opinion. Because it keeps going on and on. It just never stops, and it will stop when you have to pay the same price for lying that you caused somebody else to spend time in jail. I think that would stop it, don't you?
You would think that that would have a big impact on those in that position.
So you were born in Holyoke?
I was born in Holyoke Hospital.
Hospital, so you never lived in Holyoke?
I never lived in Holyoke. I grew up in Cincinnati.
It's a shame.
Spent a lot of time in Holyoke. I remember going down to Steiger's on I Street with my parents when I was
You did something in Holyoke with homeless people?
did
Tell me about that.
worked for a group called Families in Transition. And I don't know if it's still the process today, but homeless families in the 80s were frequently placed in hotels by the state when they came into the system and had nowhere to live. And families living in a hotel room is a horrible situation. Where you have a mother or father or a single mother, several kids, there's no kitchen, there's situation. So I work for a group where we help to, because most of these young families had become homeless through issues that had arisen, had become evicted or things of that nature, had a real difficult time finding apartments or getting into. So we go out with community landlords to secure properties, and then essentially our organization would lease the properties, and they would essentially become subtenants of ours. So if there were issues of non-payment of rent or such, there was some safety net there to hopefully transition them into our program and then on to a housing situation of their own. Did it for over a year.
It's quite a
Challenging work. Anyone who does social work, I have the utmost respect for.
So the deal with me is with regard to having criminal, and that's all I've ever done is criminal. I find is that, not all, but some judges that don't have the experience in criminal kind of take the easy approach in the middle, which is to be pro-government. Don't get criticizing for your rulings if you're ruling in favor. So that's what I'm concerned with, whether you're going to have the fortitude to stand up to the prosecutors. It's not easy sometimes. There'll be a lot of pressure on you in certain cases. Be people sitting in a courtroom that have had a loved one killed or maimed or some sort of abuse inflicted upon them. And you got to make the call. And it may be a call that's against the prosecutors. And I know you're going to tell me that you're going to do that. I appreciate that. I've been told that by everybody that sat in that seat And not everybody that sat in that seat has done that after they got a roll and get on a bench. So I'll ask you whether you're gonna be the fellow that can.
I can. I will not take the easy approach. I guarantee you that.
McDonough out there just made a big ruling in the Hoyle Silverstone case. I can only imagine the pressure that he had on him, and the pressure that he thought of in his lobby. Made the call. I consider him one of our best judges also. So you're gonna be able to do that.
They will.
So if 2 years from now I go into the Springfield court or in any superior court that you're in, I'm not gonna hear lawyers say, oh, forget it, he's all government. I do. I'm gonna call Judge Callan and ask him to call you, okay?
I'll welcome your call.
I got a couple of things here, a pet peeve of mine. On your application, you answered a question, it's number 46, you don't have to look it up. Have you ever served as a master or arbitrator? If so, please describe blah, blah, blah. You put NA. What does that mean, NA?
Not applicable. But so the answer would be no, I have not.
Why didn't you put no?
Not sure. I guess just,
Not applicable, see, doesn't tell me anything. Right?
sure.
I don't know what that means. I was an arbitrator, I was terrible at it, and I don't want to tell you that I was terrible at it, so I'll put NA, right? So your answer should have been no.
Should have been.
Very important to be a judge, to listen to the question and answer it, right?
It is.
Next one, 47. Have you served as an administrator, executor, trustee, receiver, or in any fiduciary capacity? What's the answer to that?
There is no. I suspect I put NA.
Did. Have you ever served on any bar association referral panels, criminal justice panel, legal aid, or public defenders boards of directors in the last 5 years? The answer, you put NA. You put more NAs than I've seen in any application since I've been here. I was amazed when questioned about why you want to be a judge, you didn't put NA. Describe any substantial legal experience accomplishment that you think should be considered. NA. That's,
I put none.
or,
No additional.
okay. List any programs you might have taught at which you've lectured. Did you ever lecture anybody, any?
I did a MCLA
It's important.
with
52, you put NA.
but that was I spoke at one MCL matter on personal injury cases.
That's big. That means somebody thought enough of you to have you come and speak. You want to know that stuff. Helps you to put the answer. List all books, articles, or other publications you personally have authored.
Put NA. I guess I used NA incorrectly.
I know it makes it easier to fill out this damn application, which goes on forever, but I don't think it helps you. You ever been elected to a public office? Not applicable. Why wouldn't that be applicable? That would be applicable to us. We'd want to know that.
I have not.
Okay. Other than as counsel, have you or your spouse ever been a party to or been involved in any civil legal proceedings?
I have not.
But not applicable. That could be applicable. She said, yeah, I got sued 14 times so far for my practice of law. We want to know that. Property owned by you or jointly with others, including property held in real estate trust or legal entity in which you own an interest, been either judicially or non-judicially foreclosed. So none.
Yes.
Or no? Have you ever had an assignment for benefit of creditors? The cases you cite, I've read them. I don't, unless I'm reading them wrong, I don't know who you represented in them. No, I read the case like the Ryder Funeral Home case,
I represented Will Ryder.
but you don't know that from reading all of this, or at least I didn't. Yeah, I know about that case. Have you ever had any, this question here they ask is, if you know, have you ever had any bar complaints?
I am not aware of any bar complaints.
That's my point, though, that I'm concerned with, not aware. I don't like the question, first of all, saying, are you aware? I can't believe any lawyer on this earth would be aware of a criminal, BBO complaint.
I've never received a BBO complaint.
No, I'm saying, the question says, if you know, which means somebody might have filed a BBO complaint against you and you don't know about it. Every lawyer knows as soon as a complaint is filed, don't they?
Right.
So the question shouldn't be if you know, it should be, have you ever had anything filed against you? Have you ever had anything? Not even a complaint that was dismissed at the BBO. What else? You're a writer. You write a lot on these cases. Usually we don't get this.
I enjoy,
You like writing?
I do enjoy writing.
You're going to need that on the Superior Court. Let me just ask you another couple questions about some issues. You know if there's a dress code in the court
There a dress code?
system?
Do not believe there's a dress code?
Okay. But yet I see judges berating somebody that comes into their court, a pair of shorts on or a t-shirt that doesn't have any offensive stuff on it. To me, when I see that, I understand that the person standing in the court probably doesn't have the clothes like we do to go to court. I mean, nobody's ever taught them how to dress anyway. But I saw a judge ridicule a fellow once for quite some time in front of a whole full courtroom of lawyers. And it wasn't a good look for the judge at all. So there is no court dress code as far as I know.
There is not, as I know, and as you point out, I agree that a lot of the people who appear in court come from a different background, different financial situation, and I don't feel there's any.
Isn't it more important that they're there? Sometimes people in suits don't show up for court. I want to ask you about the sentencing guidelines. Have you ever heard of them?
Yeah,
Think of them.
I think they're guidelines. They provide some information that may be useful formulating or considering, evaluating a situation. But they're just that, guidelines. My understanding is they are not and have not been adopted in any way and are just that, something to consider like anything else out there.
Well, Judge Brieger, who's here, has been kind enough to give me the information on how the guidelines were brought into existence. And I'm reading that now, trying to change my mind on my thinking guidelines. I don't like guidelines. I don't think they should be brought up in a courtroom. The legislature is the only branch of government that can define a crime and define the punishment for that crime. No group of people sitting around talking about how we're gonna make this even for everybody. I don't believe you can make it even for everybody. The fellow in the Suffolk Superior Court charged with a crime, fellow in Pittsfield charged with the same crime. Two different people, two different backgrounds. Problem with the guidelines, as I see it, the prosecutor brings it up when it's favorable to them, and the lawyers bring it up when it's favorable to them. And that's starting point then about negotiation. To me, it's always been the start. As soon as they're raised, that's where we are. We gotta either try to knock them down or get them more if the prosecutor wants to get them more. They're the starting point, and I don't believe they should be. It's guidelines in the federal court for almost 25 years that were draconian. And a lot of citizens of this country in Massachusetts spent many years in jail because of guidelines. And they were criticized continuously. Why we would ever adopt them things after what they did down in that building, to me, is not good. So if you're going to allow the guidelines that some groups set up, then I'm going to show up in your court with Jubinville's guidelines. I think I got as much right to have my guidelines as they do. If I did that, you'd say, Jubinville, you're out of your mind, get your guidelines out of here. So it's my take on it. Ever been in a prison
Have,
for a crime?
for a crime, no. I have visited clients, conducted depositions in prisons.
House of Corrections, have you been?
I have been in the House of Corrections, meeting with clients, and like,
I think anybody that has the power to put people in a cage should spend time in that cage. Should go in and see it, see what it's like. Even spend a night to see what it's really like in those places. I know you haven't spent the night there, but
not thankfully.
what do you think of the report by Judges Gantz, the Harvard Group on racism in our court system?
I reviewed it. I think it's very concerning that there is a clear difference sentencing or times sentenced that varies among races.
Well, the report is explicit that minorities, black and brown people, far outnumber white people in proportion to the population. In cages, I call them cages, that's what they are. Did you ever go to the zoo at the Forest Park?
I don't know. I don't have a recollection. I may have when my daughter was little. I've been
Yeah,
there.
when I was a little kid, you see the lions in the cage, the tigers in the cage, right? On the cage. Nowhere in America is an animal in a cage anymore. You have roaming areas, except for humans, we put people in cages. Judges do. You're going to be a judge, so you're going to put people in jail. So if you do it enough, you're adding to the problem. We say, why are there so many black people in jail population than white? Because judges put them in. The only way to get them. You ever do any lobby conferences?
Yes, been the conferences.
Get them.
They're useful.
You can do them all the time. When I first started, great way to get rid of cases, resolve cases. You ever heard anybody say anything inappropriate in the lobby room?
Not any that I was ever involved.
There's usually an assistant clerk in there, sometimes a probation officer. Sometimes they're even bringing a stenographer. Then we had stenographers do it. I know that the powers that be recommend you don't do them, but they still do them in certain courts, and I think they're pretty effective. Um, A lot of people are on probation in this Commonwealth, in my view, but then should be. And we have new tools. We have ankle bracelets you put on people to release them. My view that it's gotten to be the fallback place. I mean, you've got more people walking around with bracelets and bail and restrictions, and they haven't even been convicted yet. So I don't know whether you're familiar with those or not.
I am aware of those issues.
We've developed a new culture now with these bracelets. Lawyers are going in, and I've done it myself. Tremendous amount of time is being spent on my guy would like another hour on this end. He'd like to report to work early on this day. You're constantly going in to tweak those time frames. It's creating so much work for judges and clerks in our system. I think too much they're used too much, but that's just my look at it. Have you ever heard of an Alfred plea?
Yeah,
Think of those.
I think they're a useful tool. And I think it is when a defendant either is not able to or is not to, but wants to accept the sort of deal that's there, it should be allowed.
Okay. I think that's about all I have for you. Yeah, that NA, it's on everything you did.
I apologize for using that. It's not my intent to in any way try to not be clear in what I was saying.
Thank you,
Okay, well,
Councilor Jubinville.
Let me leave it, that, thank you for answering my questions. I remember when Judge Callan was here, he was asked an awful lot of questions. He didn't have much criminal. I remember his testimony, and he was very good at it when he testified here, and to me, it made a big difference. You've been testifying good too. I like that.
Thank you, Councilor Jubinville. I would also suggest that Judge McDonough, when he first went on the bench, had done primarily, well, actually only civil, with a smattering of the criminal, like Mr. Manitsas has had in working on civil cases. And I think both Judge Callan and Judge McDonough are excellent examples of people who were civil litigators who have turned out to be not only good judges of criminal and civil matters, but also have the courage of their convictions in hearing cases. So thank you very much. I'd also like to introduce Councilor Kennedy.
I'm sorry, I thought you were through, sorry.
Councilor Kennedy, do you have any questions?
Yes, I do have a few. Thank you. I apologize for being a few minutes late. I had a judge that was a little ornery keeping me in court beyond the time I wanted to be there. Have you ever been yelled at by a judge? You know, don't you wonder why they do that?
Well, sure.
I mean, I've been yelled at by judges over the years. Certainly, I've been doing this for 38 years, and less so as I get older. I think it's because I'm older they yell at me less. But I see it all the time. You see these judges that get very cranky, that are yelling at lawyers, yelling at litigants, and I always wonder why they do that, because there's absolutely no reason for that, and it changes the whole demeanor of the courtroom. Could you see a situation where you lose your temper and be yelling at people? How about locking a lawyer? Would you ever see any scenario where you would put a lawyer in custody?
You're not.
That happened not too long ago out in Central Mass, where a district court judge put a lawyer into custody. I talked to that judge about that. I talked to a lot of people about that. And there's no question that it was completely and totally not justified. And I got, the Council Jubinville talked about the situation, with Judge McDonough's decision on the lab scandal and what should happen to them. But one thing I disagree, I don't think we should be locking lawyers up. I think that undermines the whole system. How would you handle a situation with a lawyer that, either wouldn't, stop arguing? You've all seen that. They won't surrender, even when it's clear the judge is ruling against them. I've done that. Or just somewhat disruptive in your courtroom in some manner. How was that?
I think you do have to, take control of the courtroom. Be firm and indicate, that arguments are over, we're moving on. But understand and also power that the court has, ultimately the court is the decider of any issue. So there's no need to yell. There's no need to, do more than issue the decision. And so I think by just being firm that the argument is over, thank the counsels for their impassioned position on this, but we're moving on.
Okay, but I keep arguing. I keep going after you say that. What are you doing now?
I guess I would try to diffuse the situation.
Okay, and I keep arguing. I'm not stopping. I've seen that. I've seen it.
And I'm gonna continue to try to diffuse the situation. Maybe we need to take a break. Maybe we need to say, take a break now. We're gonna go off, step off the bench, let everyone cool down.
I mean, Counsel Jubinville's a great lawyer, and he's making the point right now that he wants to make, and he won't stop. He thinks you're wrong, and he won't give up. How are you gonna handle that?
As I said, I
He
will.
doesn't surrender easily.
We'll look to diffuse the situation. If it ultimately gets to a point where I need to, I would take a recess to diffuse the situation even further.
It always astounds me when I go into a courtroom and there's a judge that, and we know who they are, it's usually the same judges all the time, that are cranky all the time. And they hate being out on the bench and they hate the job, and they're just cranky all the time. I just don't understand it. It just makes it much easier for everybody to move along when it starts from the bench, the civility. And that's where it should start. Okay, so you know what the big hole in your application is. We talked about it. It's been brought up earlier, the lack of criminal. You're gonna be handling some incredibly serious criminal cases. You're not in a district court, but some of those cases are serious. I'm not saying there aren't, but you're gonna be handling the most serious criminal cases that we have in the Commonwealth. You'll be handling eventually murder trials. You'll be handling serious allegations of rape, serious assault cases involving weapons and things of that nature. What have you done to get up to speed in terms of criminal work?
Well, I mean, recently I've reviewed sentencing guidelines. I've started to look.
I'm not a big believer in sentencing guidelines. We'll talk about those in a minute, but go ahead.
And just trying to educate myself on criminal procedure and looking at the criminal law side of things.
One of the things that I have found, and I think you definitely are a qualified candidate in terms of your experience in the courtroom. What I have found over the years is people who only have a civil background, and I've brought this up countless times with people that are coming from the civil, a civil background. And then they say, no, I'm not going to do that. And then they get on the bench and they proceed to do exactly that, is they tend to defer to the prosecutor because it's a safe way to go. Somebody's coming in on a serious assault and battery, dangerous weapon, maybe a stabbing, and the prosecutor's standing there saying, this is a really serious case. We need $25,000 cash bail. The defense lawyer's standing there saying, she's like, yeah, but There's a good self-defense case here. This kid's a college student with no history or minimal history. You know, we gotta let him out. My experience is when somebody comes from a civil background, at least when they first get into the job, they tend to defer to the prosecutor, both in terms of bail arguments, in terms of dangerousness hearings, and in terms of sentencing. What are you gonna do about that?
Well, I would be very reflective in any decision I made. I'm sure I am not doing that.
That's what everybody says. And then they go in and they do exactly that. They tend to defer to take the safe route. You know, for some reason, judges are afraid of ending up in a newspaper if something happens with someone they let out. I don't know why, because they can't fire you because of a decision you make. You follow me? And I hope that when you're on the bench, when you make a decision, that's not in the back of your head. If that's why they defer to a prosecutor, because it's the safe route. Okay, what do you know about dangerous hearings, Mr. Chairman?
I'm familiar with they proceed. You know, the prosecutor at the initial stage can ask for a dangerousness hearing, and ultimately then the court will determine whether hold the individual or are there less restrictive manners to guarantee the safety.
Do you think they're overused in this state? Filed too often, 58 days?
Yes, I don't have a basis to say how often they're used.
I can tell you they are. There are a lot of prosecutors' offices that filing in every case where there's an allegation of domestic abuse. They may be appropriate in a lot of cases, but in a lot of cases they're not. But they file them in every case. They file them in cases, frankly, that they just shouldn't be. And a lot of the judges I talk to agree with that they're frustrated because they file them in every case. Do you know what happens to the defendant when that prosecutor walks into a courtroom and files a motion to have somebody held as dangerous?
You say what happens?
They're automatically held for 3 days. They're put in jail. People that would never go to jail on any case, on this case, if they were found guilty after a jury trial, are being held in jail. People with no history are being held in jail. And a lot of times they're on cases that are going to be going away. They're going to be dismissals, they're going to be not guilty. They don't have to be held in jail, but most
Is there a problem with the transmission of what's going on? Hello? The video and audio are frozen. I can't hear anything or see anything. Excuse me, we're going to take a moment's recess. I have no feed. There's no video or audio. Valerie, can you give me a call on my cell phone, please? To let me know what's going on? And if Valerie doesn't have her cell phone, Sonia, can you call me, please?
Your call has been forwarded.
I have no video, I have no audio.
Audio?
Nope.
Okay, let me talk to Sonia and see what's going on.
Take,
Can't hear anything?
I have no picture, I have no audio. Could you just tell them that that's what's happening and I'm taking a short recess?
Want them to pause the hearing?
Well, it won't be
Or do you
on,
want them to keep going?
it won't be on. If I'm not hearing it or seeing it, is that a problem with everybody else?
I don't know, but if you're not actually, I mean, I can't troubleshoot.
Way back when.
No,
And
it
they,
just came back on. It's okay.
You're back on.
Yep.
Okay.
and they have no place in the courtroom. They tend to cause the judges not to look at the individual case and the individual person. You know, I walk into a courtroom, the first thing that a judge asks in Superior Court is, well, what do the guidelines say? Probation jumps up and says, well, the guidelines say. I don't care what they say. I want you to look at my client and what he's doing to fix it, because at this point, we're at a sentencing, it's not a trial, it's not a hearing. And, you know, what we can do to keep him from getting back there, and what the appropriate punishment is for him, given all the circumstances. And the guidelines don't consider that. They just don't. So so I hope that you don't, I hope that you don't even look at them. I hope that you look at the person in front of you, as opposed to the guidelines. That's my concern with you. I'm gonna be voting for you. We had a long conversation on the phone, but obviously the lack of criminal experience. I do a lot of criminal work, but I also do a lot of personal injury work and some civil stuff. So I think we need some people on the bench that have your background. Most of the people seem to come from the criminal bar as opposed to the civil bar. It's funny how it seems to be the opposite in terms of the way the lawyers act. They say less civil than civil. But we need you there, and your colleagues need your expertise and experience as well. I hope that you give that to take what you're bringing to the bench, share that with them and that knowledge. And I hope you take that from the folks who that have been there and have learned practice in the criminal arena. You're going to be a great judge. I wish you well. We vote for you next week. Thank you.
Thank you very much, Counselor Kennedy. For your information, there was a couple of minutes where the feed, the audio and visual feed for over WebEx went out. It was not intentional, and it's not something that was.
That's because I was yelling at him, Mary, and I didn't want people to hear it, so I shut it off.
Thanks. In any event, there was no intention on anybody's part to cut the hearing off. I would also indicate it's now 11:42. We expect to have to break around noontime for the Lieutenant Governor to come in for our assembly. All the parties can stay in the chamber, but they will have to just take a break. Counselor Duff, are you there?
Madam Chair. You know, I really, the other counselors have talked a lot about the issues that concern me. We are, you know, we all know the criminal and everything. What you have though, to me, is something that's intangible. That we don't see on the resume, and your resume is good and it's important.
Forwarded to you that night.
You have, this came through very naturally to me. It wasn't something that I was trying to drill down at it or anything. But you have a very good sense of compassion or empathy for people. And open-mindedness about different situations. You know, I've always been one that's talked a lot about, as I think some of my colleagues did today, the need to be able to be a prolific writer. This court. But I think, in, from the beginning of my tenure on the council, I've always sought the quality that can't be quantified. That's a risk. It really is. I mean, come before us, it looked terrific. You wouldn't have gotten this far in the process if you were smart and did. I have to agree with Council Jubinville for sort of niggling you a little bit on the NAs. We see that a lot in these applications, not just you, but I think the reason, I can tell you the reason it matters to me. I can't speak for the other councils, but it matters to me because it shows commitment in conviction in your answer, even though it might seem a very, not that, in law, it's one word makes a difference. That I have a sister that formed and she's brilliant. She's had people sign and they go, oh no, that's not what we said. She says, well, you best read the contract because one word makes a difference. So I think that's where my but not to belabor this, I really don't have concerns. I was quite satisfied with our conversation. I was frankly happy. Surprised in some ways. I'm not finding the right word. You spoke to me very authentically about being open-minded about people. And I think that's the most important thing, because the most important day of somebody's life is the day they appear in court, whether that is Superior Court, Probate Court, any court. Well, you know, that's what it is. I was sued a couple of years ago by someone who ran against me in a completely frivolous lawsuit. And it cost me a tremendous amount of money. I didn't make a big deal about it, but I did it. I went to the first level, and then he appealed in Superior Court. I had to go to Superior Court. It's a nerve-wracking experience to see, you know, how it works. So I come to this seat where I sit a little bit differently than my colleagues, and that's what makes this body so impressive. And we all come to life experience, and that's what matters to us if you ascend to be a judge. So that's my little questions. I think my colleagues have covered to the really, really well. So thank you, Matt.
Thank you, Counselor Duff. Counselor DePalo?
Yes, thank you. Good morning. I won't rehash what's been said. I will say that there's a lot of hyperbole sometimes at the hearings, but this is the thickest stack of letters that I've received for any nominee since I've been here. And that speaks well for you. Beth Morris is extremely well respected. As far as I'm concerned in Central Mass, and Fran Ford, as you probably know, gave me a call and he spoke to your temperament, which is important to me. Councilor Kennedy, Councilor Kennedy's line of questioning around locking up lawyers. To me, the reason that's so troubling to me when I hear about attorney being locked up in a rather frivolous way is it makes me question how a jurist is going to treat defendants who come before them. Pursuant to Councilor as well. So I was glad to hear your responses to that. Councilor Jubinville brought up the Harvard study commissioned by Chief Justice Gant. Let's talk about the specifics in there because they really point to sentencing and they point to the charging phase and then to sentencing in Superior Court in particular. So it's an imperfect report because it certainly could use a lot more data to get to the bottom. But I think they did a good job of using available data. And what they found with Black and Latino defendants are twice as likely to end up in Superior Court when there's concurrent jurisdiction between district and Superior Court. Why do you think that is happening in our system?
I think from the study, the sense is that prosecutors are, say, overcharging, but charging Black and Latino defendants higher level than they are, say, their white.
Does that disturb you? Is that alarming?
Alarming. I think any type of, and I think the study didn't suggest that it was intentional.
No.
It underlines our understanding of implicit bias, and I think the import to take from that is I think we all can be aware of those issues and try to take the steps in our own decisions to avoid those things coming into or being aware of those things so we can not work to have them not affect our decisions. And I think that starts from rest through the charging and all the way through to sentencing.
Because sometimes I hear things like, this kid is a college student who hasn't been in trouble before. And I think, why in the hell do I care that this kid is a college student? Because I was raised thinking I was going to go to college. My parents helped me apply. I went to college. It's not because I was an upstanding citizen by any means, right? And it's like those little things that lead us to having the highest Latino incarceration rate in the country. That's really alarming to me because it speaks to how people are entering the system and being processed through. So you just mentioned being cognizant of things. I try to ask nominees what can be done about this, and it's hard to pinpoint, and being cognizant is an important first step. Are you a member of the Mass Bar Association? Would you say they're a radical group?
No.
I wouldn't either, but they've said that we know what exists, from what we know exists in the Harvard study and elsewhere, that there are things that can be done. Commutations are one thing that can be done. The MBA says that commutations are an immediate, targeted way to address the disparities that we see. Does that sound reasonable to you?
Does that sound unreasonable, Doug?
So there's hundreds of commutation applications that have been submitted or petitions in the last several years. And yet in the last 6 years, there's only been 2 hearings held. I believe there is a third that's been scheduled but not held yet. Do you think 2 out of hundreds of applications, when we know that our system has areas that need to be remedied, is adequate for the parole board to be taking up?
I really can't comment other than numbers seem to support what you're saying.
And what the Mass Bar is saying, really.
And what the Mass Bar is saying. I don't personally know. I haven't reviewed any of that, but that does seem to support that's a position there.
Really briefly, you said you reviewed the sentencing guidelines. I'm similar to my colleagues. I don't like the sentencing guidelines. Nonetheless, you reviewed them, and there are some, obviously they were put together with thought. The funny thing to me about the sentencing guidelines is there's the sentencing guidelines, and then there's all these mitigating and aggravating circumstances that you should try to take into account, which essentially means what you should be doing from the get-go is evaluating it on a case-by-case basis and not looking to the guidelines to create some kind of framework for where your thought is going to go, right? And it's very tempting for us as humans, implicit bias is part of us, but the desire to have objectivity and to frame things. Like, oh, here's my range of sentencing, and I'm going to go forward and navigate that range. One of the mitigating factors that they suggest in the sentencing guidelines is the age of the defendant at the time of the offense. Do you think that's something, regardless of whether you refer to the sentencing guidelines or not, is the age of the defendant at the time of the offense something that you think's worth considering?
Absolutely.
Why do you think that?
I think we know, I think studies have shown that the development of the mind, I think just from personal experiences, what young people do and mistakes they make is something part of growing. So I think that is a very important factor to consider in any sense of age.
And besides the pace of development, we also know concretely that trauma in childhood exacerbates the delay in development, the delay in executive functioning, impulse control, things like that. And you worked very impressive work working with homeless families, right, trying to transition. So you've seen families going through trauma, and I assume you've seen on some of the children in those families, right? Let alone the housing disruption, the school disruption, the shame they're feeling in school, bouncing around districts. A lot of those kids end up in our criminal system, right? And so I hope that if you take the bench, that you're taking into account the fact that a lot of these folks end up in our criminal system predictably. Councilor Jubinville and Kennedy discussed, in our corrections facilities, we have severe problems around access to mental health. It's been well documented by Donald Trump's Department of Justice. I'm not concerned really about your civil, your bent towards civil, because we need that in the Superior Court. So with that, I have no further questions. Thank you, and congrats on your nomination.
Thank you. Anyone else have any questions?
That's why I'm here.
Counselor Devaney.
Thank you. Always the first one here, the last one called. Right now, it's 5 minutes to 12, and the Lieutenant Governor's coming in at 12. I'm not going to shortchange you. More than 5 minutes of questioning for you. I'm going to be presiding at 1 o'clock, okay? The last time when we had 2 in one day, 1 at 1, I was alone here, presiding till 1:22 when the councils came in. So I'm making an announcement that the councils cannot go to a restaurant for a full lunch and come at 1:22 again. Expect it's going to happen at 1. This is on the newspaper. It's published, it's posted on our website, 1 o'clock, and it's not going to be disrespectful to the nominee. Have 30 minutes. So I'm going to be questioning you, and then unfortunately, probably after the hearing, after the assembly, I will be asking you again. It's too bad that this wasn't scheduled for 2 weeks for today, December 15th. And that would have been fine, you know, but I have no, I scheduled, and we should have 1 a day. And back to you, and back to every. So, having said that, first of all, nice to see you again. Thank you for coming from distance. But I have to tell you, didn't break Justice Island record in coming to the diner. So, but that was a long ride. I hope you didn't get a lot of traffic on. So, okay, I always ask the nominees to go back to the journey that brought you here. So, first of all, I like the public. The governor, 21 lawyers, and those 21 lawyers have amazing responsibility. I don't. Excuse me. And we don't have, governor's councils don't have that authority. We only can vote yes or no on someone. If you can imagine, 21 lawyers are appointed out of all the lawyers in Massachusetts. So if you're one of those lawyers, you have the responsibility to choose who you're going to interview, not going to interview. So wouldn't you think you'd be there, right? In this administration, never been one nominee, 21 people. So I'm going to ask you, and then they vote, not seeing you, not hearing you, not talking to you. I'm saying you, but I don't mean you. Okay, so tell me, how many of these lawyers
10 on.
Okay, so, okay, 10, so we'll say 12. So, now people. And yet, you know, it's such an awesome responsibility. I can't get that through to the administration. That's wrong. I've been here 21 years. No JNC has ever done that. So, you know, so I'm venting, so I appreciate you letting me vent. Okay, as far as the NA, a lot of the, I've been here 21 years, a lot of the questionnaires have NA, but not as many as yours. And I'll tell you why. You think it's not important. For example, I think the most important, one of the most important qualities of a judge is to listen and read. Listen to a question. To the, if a question is asking you if you've been in the military, if you and so an elected office, you put NA, maybe you ran. I'm just saying that NA is not right to me. I've seen it so often, but yours, you got the prize, you got the most. But I just want to tell you that. And because I know.
Say this, from this day forward.
Well, the thing is, you know, writing is so, to me, in the Superior Court. And we just had a judge that said it was too much writing, so he went back to the court. But I like that about you. You can see that in your questionnaire that you do like to write. And you know, I'm really happy with that because lots of times I'll get a JNC questionnaire and it's just bare bones. I really don't understand what the case was because they're not really saying very much. It was complicated or whatever, the adjectives, but you really put it out there and I can understand it. So I am very pleased with that. So, but I do want to say that when Judge Callan came before me, for us 5 years ago, I questioned about having criminal experience. And my whole thing about criminal experience in Superior Court is that, and I just feel if you're an attorney and you've never had criminal cases, you're sentencing. That's the thing that bothers me. What I like about you is your private practice. Practice been responsible for everything. For it's for shoveling the snow, paying the rent, all of that. And I think that's what that means a lot, because when you see someone coming in, lawyer is with a class lawyer.
Okay, yes, excuse me.
You know, that's the thing. So we're going to be interrupted now. The Lieutenant Governor's coming in, and I will continue afterwards. And I'm asking, 1 o'clock is the next hearing. Please don't go to a restaurant and have a full lunch because I'm starting at 1. Thank you.
Okay, we're going to take a recess to do the assembly. Attorney Manitsas, you can have a seat near your wife, and we'll come back in session. I assume all of the counselors are aware of the fact that Governor Baker and Lieutenant Governor Polito announced that they will not be running for another term.
We got boxes to help them pack.
Stop.
Good morning, Lieutenant Governor.
Oh, sorry.
Okay, ready? Call our assembly to order, and I recognize Councilor Ferriera for our prayer and pledge today.
Thank you, Governor. On this momentous day in the State House in Massachusetts, where we just learned that the governor and lieutenant governor are not going to be seeking re-election, I would publicly like to thank them for their incredible service, selfless, and the hardest of any time I think any governor and lieutenant governor faced in our nation. So I really, truly, on behalf of the council, appreciate your support.
amazing selfless service, 24/7 for 8 years is unbelievable. And I just pray that the next contenders are up to the task and do it as efficiently and as gracefully and as bipartisan as you have. Thank you.
Allegiance to the flag
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Q. Recognize Councilor Jubinville for a motion to record advice and consent for the financial warrant.
Second.
Second. The motion in a second.
I have a question on,
The motion in a second.
I'll probably see Attorney Ross on it. I have, there's 3 items there that doesn't give any background information on it, and I really would like to have him follow up on it. I will see him on it, because it says to see Section B, Schedule B, and there's no Schedule B.
We'll make sure that you have those materials. We have a motion and a second. All in favor, say aye.
Aye.
Would you like to be recorded as not voting on that?
Yeah, maybe I will, and I'll wait, because he's very good if they need me to respond.
I recognize Councilor Ianella for a motion to record advice and consent for the pending list of notaries, public, and justices of the peace.
Second.
Motion in a second. All in favor, say aye.
Aye.
And I recognize Councilor Jubinville for a motion to record advice and consent for the appointment of Stephen W. McLennan to the position of Associate Justice of the Boston Municipal Court.
I make that motion with great pleasure.
Second.
Second.
The motion in a second. Councilor Devaney.
I have to talk for this nominee. I don't know how to say it. He touched my heart. In 21 years, I have never met anyone like him. And I have voted for wonderful people. I mean, Judge Callan was here today. I have voted for good people. But his background is really the American dream. And as you know, I meet with everyone. And I don't disclose anything personal that anyone tells me. And I said to him, can I tell public you told me about your personal life? He said, absolutely. So Stephen has given me his permission. I want the public to know. I don't cry. First of all, his mother was 15 years old. Gave birth to him. And he was brought to a foster home. And wonderful foster mother. He had a foster brother, sister. And when he was 4 years old, he was adopted. If you can imagine, as a 4-year-old boy taken from the only home he knows, he's crying. The foster mother doesn't want him to go. He's crying. And even his adopted father said to his mother, are we doing the right thing? And she said, he'll get over it. And he did. And his mother and father were the most devoted people. Father died young. Mother, there's such a relationship between his mother and himself. So here's someone that through all of this, who had nothing, who coming from that background, could be a judge. And that to me is the greatest thing to know he'll be on the bench. Because I talk all the time, Lieutenant Governor, about that I won't vote for anyone without compassion and empathy. He has it. He's been there. He knows. And he cares. But not only that, he's so qualified and he's so experienced. And he has helped so many people pro bono. He helped someone help that child in school, bring him home, feed him, do his homework, and everything. That's the kind of pro bono he did. So I don't want to belabor this because I could go on. He has a life, he has. And I just can't be more enthusiastic as you can tell. So I'll be proudly voting. Thank you.
Thank you. Anyone else? Okay, so we have a motion and a second. We may commence the roll call.
Council Ferriera,
Yes.
Yes.
Devaney, Gonzalez, the Duff,
Yes.
Kennedy,
Yes.
DePalo.
Yes.
Counselor Hurley.
Can't vote remote.
That, okay. All right, thank you. Thank you for your kind words. And that concludes our business today. I know you have some hearings that are pending.
Good luck.
Thank you.
Thank you, Lieutenant Governor, for your service.
I miss you.
We're gonna miss you.
Whole year.
Not leaving.
Work to do.
It's got a year.
A whole year.
Yeah.
Lots of work.
Okay,
Thank you.
we're gonna go back to the questioning of this nominee. Councilor Ferrara, do you have any questions?
I do not, but thank you, Madam Chairwoman. You're doing a great job in this hearing today.
Thank you.
Is there anyone else that you want to call on first?
Nope,
Thank you.
it's acknowledging that.
As I said, I'm always last, but as they say in the Bible, you'll be first. So anyway, it's such a pleasure to meet with you. And it's very important to me to meet with you. I'm not just voting for someone on a piece of paper. I'm voting for the whole. And I was impressed with everything you've done. And what I like about it is I said that you have been in solo practice. My only question, tell me the sequence, how you were in private practice yourself, and then you went solo 2 years, 3 years, and now. How you made those decisions to make those changes.
When I went president,
I don't want to interrupt you. I'm going to wait till they all leave. This is supposed to be a hearing. Anyway,
Counselor,
so
what is
tell
your
me
question?
about tell me about, how you, 2 years of this. And then you ended up.
so after getting law school, I went, was working as a bar advocate and
Can't hear your responses, Jim.
sure, and learned we were expecting our daughter and ultimately looked for something more secure. A family in a way. So I took a position with the staff office at Century Insurance, worked there for and then went to a firm and worked with the plaintiff's firm for 7 years before 17 years ago, going back out into private practice. At that point, I made a decision to want to have my own office, and 17 years ago, went to private practice.
What I like about private practice is you choose who you're going to represent. And in all due respect, we've had great people from Attorney General and the District Attorney's Office, but they're given a case and they're halfway there when the police gives their report, but you've done it from scratch. And you've gone beyond in helping these people because you get personally involved in the cases. One of them that comes to mind out of your cases was so tragic about that, they went to the wrong house and ended up getting killed. So you did have a murder case. So tell us about that one.
So I handled a wrongful death action that was brought against my clients who were homeowners. Tragic series of events. A series of 3 young people, about 15 or 16 years of age, were at a home. They were drinking, became very intoxicated, left to go meet some other friends, and then were coming back, or thinking they were coming back to the house where they had been at this party. Because of their level of intoxication, they actually went to the wrong house. and the homeowners were there that evening. The gentleman had just come home from work. He was asleep. His wife was there. 2 young daughters were there. And these 3 individuals come to the house, start pounding on the door, pounding on the windows. Tragically, these 3 young people thought their friends were inside playing a joke on them. So this pounding and banging worked and worked. The wife then woke her husband. He had a gun. He went to his gun safe, retrieved the gun, and then went to the kitchen with the intention of calling 911. They in fact called 911. And as this occurred, one of the young men was at the back door, I think hearing them inside, began to pound harder and broke the glass out of the door. Gentleman who I was representing was in that situation, believing that this person was coming in to the door, through the door. He was there with his wife and 2 young children. He fired one through the door and unfortunately resulted in the death of this young man. It was a tragic case. I handled the wrongful death side of it. Attorney Flanagan then, now Judge Flanagan, handled the criminal side. Fortunate that we were able to reach a resolution of that case for the family and everyone involved. As I can say, no matter what side you were involved in that case, everyone was profoundly affected by what had occurred.
That, I read that and I thought, oh my God. I put.
Marilyn, we can't hear
Their friends were
you.
playing joke. How tragic. And I'm being interrupted. What is it?
We can't hear you. You've got to sit closer to the microphone.
We don't have a microphone. Okay,
All right.
so anyway, so you would tell me about the, I don't know how often it happens. Every now and then I read about it in the newspaper about funeral home, because the ones, people that I know from Watertown, they're wonderful and we trust them. And I can't imagine that cremation, that case that you had. Tell us about that. That is so unacceptable, is minor to say about it, how that was dealt with.
I represented a funeral home, a long-standing funeral home that had been in South Hadley for decades. It was a family-run business. I in fact grew up in South Hadley and knew people who had been involved in that. The funeral director unfortunately was experiencing some emotional problems in his life that led to the mishandling of about 9 different ceremonies. Ultimately, there was one family whose loved ones' cremated remains were lost. File tried that case to a resolution.
It was so much more than that. When they went to the funeral home, if you want to talk about it, it's so terrible, the conditions that they found, bodies and everything, you know? So that was more than that. Well, thank you for coming.
Thank you.
Good to see you.
No, I apologize. I haven't.
Judge, I am so thrilled you came. Thank you very much. Thank you. So, yeah, so what is the penalty for the, oh, that?
Well, there was civil liability to the nursing home for the damages that were suffered by the families who had lost their loved ones' remains handled. Sentenced period of time in the House of Corrections.
I'm sure that he lost his business after that. Did they close it down or did he?
Yes, they closed him down.
I would never accept that. That's terrible. Now tell me about the one that you had, was that there was an alleged sexual abuse involving plaintiff and his stepdaughters.
So there was a defamation trial that I handled that involved a number of families. There was an incident that occurred with two young girls during a play date that led to an investigation of a gentleman for sexual abuse of his stepdaughters. The case really revolved around, or the issue in the case was whether, or what was the appropriate conduct of the other parents who learned of this information, what they should do. What they had done is gone to the school and reported what happened because these two young daughters were both in grade together. And ultimately, in that case, the jury agreed with us that the families all acted appropriately in turning that information over to the school. Letting them run.
Go to the school. I mean, I would go to police.
Well, I think I could say from the testimony in that case, the parents were not sure if something was happening or not happening. They weren't there. What they saw was not an incident involving the girl and the stepfather, but was some unusual activity at a play date. They felt that this sort of half step, so to speak, was more appropriate than making accusations. They wanted to bring the educators up to speed, expecting or thinking this may come out in the school.
Wasn't it that that it was alleged that the stepfather was telling the first grader an inappropriate way of two dolls together, and wasn't that the situation?
Essentially.
Yeah. We should break it down that it wasn't as if he assaulted her, so that, right. Now, I was a city councilor, and I learned a lot of statutes. And one of them, in your case, I thought, oh my God, that's the statute. And there's a statute that says, if I shovel a walk in front of my house and you fall, it's me. But if I don't shovel it, and it stays the same and it turns to ice and you fall, the city is responsible. You know that statute? Okay, why? Because I altered the condition of the sidewalk. Okay, the reason I got involved in that we were establishing a snow removal ordinance for residents. And if they didn't shovel, crazy, 6 hours after a snowstorm, they would be fined $50. So to me, it was a catch. I mean, it just didn't make sense to me that you're better off not shoveling the sidewalk. But if you don't, you're gonna be paying $50. So it was kind of crazy. So tell us about that one, how someone fell on the ice.
Well, I mean, I handle a lot of cases such as that. You have situations, and really those cases come down to the question of, was the homeowner acting reasonably? You live here in New England, you can't stand outside with the shovel and catch every snowflake. So I've tried a lot of those cases, and ultimately, I think my experience is that the juries get it right. They understand what conditions are like here in the state and make the appropriate decisions as to whether or not the property owners are acting in an appropriate manner.
No, but that can't, I said, that's it, that's what we're going by, but it doesn't really make sense at all to me, and that was a sad case about the pedestrian who was killed, and she got hit. She was walking her dog, and so eventually he did die. So tell us about that case and how.
Sure. So there was a case in which a young woman, 52, I guess my perspective, young now, was was walking her dog one night, and my client, was making a left-hand turn like so many of us, was just heading home from work, but unfortunately, because of the late hour of the day, some other conditions didn't see, the woman, she fell, struck her head, sort of an unusual injury. She at the scene, she was conscious and alert. Gally was transported to the hospital with sort of objective injuries. She suffered essentially a brain bleed in the worst possible place in her brain stem. And that resulted in this blossoming hemorrhage, which about 6 hours later led to her passing. It was a tragic, tragic case.
You've had some tragic cases, but you want to be a judge. So the other thing is, now this trial was supposed to take, it was supposed to be in April, so it's over now, but when you wrote this, it wasn't.
Correct.
So the result was?
The jury awarded money to the family for the loss of their loved one.
Now, tell me the one about the pizza delivery. That was something else.
Again, another sort of tragic case on both sides. I represented a young man who was actually heading from his mother's home to go meet his father for dinner. Interestingly, the night before this accident happened had been his, fortunately, that thing ingested some substances. Long and short of it was he was driving down the road, lost consciousness, crossed over the center line, struck another young man who was 27 years old, who was out actually working as a pizza delivery person, who was married, had 2 young children. And unfortunately, that gentleman passed away in the crash. And so there were several parts of that case intertwined with the criminal action that was brought, and also the civil action, and able to ultimately work out and resolve the matter for the parties.
So the writing that you presented was the case that we just talked about. So I don't know why you chose that. Was that the most difficult outcome that you had, that you were disappointed in?
Actually, the writing that I attached to my application just happened to be close in time. It was a motion for summary judgment that I think I had drafted within a few weeks of preparing the affidavit. So I think I just chose it. That was the most recent in my mind.
Okay. What is there one case that stands out that you'll always remember and that was the most rewarding outcome?
That would be probably the trial involving the families in Amherst with the issues of the reporting of the incident involving the young girls to the school. I always felt, tried that case, that a settlement of that case would have sent a wrong message, that the trial of that case sent an important message that fronted with that type of information. The only reasonable thing a parent can do is to turn that information over to the appropriate parties.
So back to the criminal side, okay. So you had your interview when?
My interview was in April.
Okay, and did you go to any course? Did you online? Did you find out any criminal cases that you wanted to do? What have you done? That concerns me.
Since my interview, well, I mean, I have reviewed, various elements of the criminal law, dangerousness hearing, sentencing, have reviewed criminal procedures, criminal rules of evidence. I have done things to make myself hopefully more knowledgeable in these.
So what would you do to be more informed on criminal cases?
I will spend the time to make myself as knowledgeable as I possibly can on any subject. After 28 years of practicing, I feel confident to say I can find the law and apply the law to any given facts, and I will do that so that any situation that I am presented with, I am fully aware of the law and am able to thoroughly and completely make a reasoned decision.
What about minimum mandatory sentence?
Well, minimum, as a judge, I'm bound to follow the law. And if there's a minimum mandatory sentence, that would be the sentence, no less than, that would have to be given out. So I would follow the law.
You know, that bothers me because I think a judge should have discretion. And we haven't had pardons, no matter how I ask for them, we haven't had one pardon in this administration. 7, 8 years. And in Patrick's, I think we had 3. And it really is bothering me because we have drawers full of in our office of people who are looking for a pardon, who had some misdemeanor, maybe, you know, stole money off a mom and pop store or of the newspapers or something. But anyway, we had someone that came in the Patrick administration, and I think of him so, and he was 57 and 58 years old. And when he was, and I think when they first made that mandatory, I think it was 4 years, and then they changed it to 2. And anyway, he was 17. And he was walking to school, and this older friend of his, 20 years old, 22 years old, ran up to him and said, "Would you do me a favor?" And he gave him 5 bags to sell in the school. On the law, so many feet from the school. He went into the, he's a young, innocent, good kid. State of his life. Never realizing, you know, what he was doing, really. So he sold 1 bag. When he tried to sell a 2nd bag, that boy went to the office and reported, and it found the bag in the locker. So he got, I think he got 4 years. So he missed out on sports. Maybe he could have got a scholarship, would have gone to college. Dates, proms, graduation, all that was gone. So when he came out, he was fortunate to get a job as a janitor, a private school. Well, guess what? Now he's before us, 58 years old, the school is closed. Even giving him the pardon without that bad baggage, where does someone that age get a job? And he's had health problems. He's had cancer, he's lost a leg, he's had other problems. But he's done so much for his community, his family, and a coach, very involved with church. And it just seemed to me, if a judge had compassion and had the discretion, we went before that judge. Maybe he would have given him probation. Maybe he would have given him community service. But he's not a criminal. And I think of him all the time, wondering how his health is. But did get another job. And just referred by these. It was years ago that did follow the law. I never heard what happened to her when she did that. I'm sure there is some, I don't know. But, you know, that's the thing that I'm not for that law. I think it should be in discretion of the judge on an individual basis, looking at that person, looking at his life with his family, and the teachers and everything. I I think of him so often, but that's the law. Now, have you had 209As?
I have,
Represent more men or women?
I've, in a few instances, I've represented an individual or a gentleman who's at a tour. I haven't in a long time, but going back, I had.
Well, what bothered me during the pandemic? You want to see someone, you want to look them in the eye, you want to see his body language. And if they're on Zoom, how do you determine if that person is being truthful? Bad enough that they're sitting there, how do you judge? How would you judge someone if it's veracity or is it, just someone being vindictive,
Well, as you point out, I mean, I think ideally, any type of hearing, evidentiary hearing would be best conducted. There's intangibles that gain from seeing someone, talking with someone, hearing someone, and that would be the preferential way to, such as that.
I understand in some courts, they were even doing it on the phone. I can't even imagine on the phone. So, it's a double sword because I have met with the Fathers Coalition and it's a little better. The fathers don't get a fair deal. And sometimes it can be a vindictive wife, so whatever. And someone early on, probably 20 years ago when I was here, and she was sent to the probate court. And a couple of years later, I looked at Boston Globe and wrote about her, and I don't have a crystal ball. I don't know what that nominee is going to do. You can say everything great, but I don't know really what is her, what is she going to do? And anyway, the father, they had toddlers, they were young, and he lived very close to them, divorced, and he would see them almost every day. And even Christmas Eve, he'd come over and stay overnight to see them get their Christmas presents and everything. He was devoted to them. Nice. And so anyway, she went to court and she asked this judge to be able to move to our with her children. What criteria? Oh, that's probate though, huh? Okay, so anyway, she didn't have anyone there. She didn't have a relative, she didn't have a friend, she didn't have a job. She was moving. So literally, her husband's going to be divorced from his children. There's no way he's going to see them. So twice a week, every day, or whatever. And so, her to be the move. Would you?
I don't practice probate.
I know, I shouldn't have even asked you that, but the thing is that, she granted him visitation, I hate that word, visitation, 1 hour on the computer, 6 to 7, you can't hack a computer, and I think of that. My only point in bringing that up, even though it isn't Superior Court, that, I don't have a crystal ball. And I have had judges that have really, really fooled me and really let me down. We had one that had just a couple of years ago, had an illegal alien before him, and who was a big drug dealer that the police were trying to get. They finally got him in court. And he said to him, and I heard the tape, said to that man, he said, if you were a citizen, I'd put you in prison. He said, but you're not, and you're preventable. So I am give you 2 years probation. I have 2 friends, Westboro and Watertown, mothers of boys who OD'd on heroin. And I'm thinking, would they think the judge that's a great thing? He's provided for his family. So I'm just saying, I don't have a crystal ball. I voted for that judge. Had I known that he would have done that, not a mean word. So that's why I'm saying that, hearing is very important. I'm very disappointed I'm the only council sitting.
I'm
very
here,
disappointed.
Marilyn.
Oh, you're in Zoom, I'm sorry. So, being the last one, I'm always the last one, standing or sitting. I have a back problem, that's why I'm standing. But, I want to thank you for applying. I want to thank the governor for appointing you. And I'm going to try to get at least a cup of coffee before 1 o'clock. I had breakfast at 6:30, but we got 2 hearings now. So I'm having someone come in at 1, and I'm starting at 1 if I'm only 1 here. It's going to be at 1 o'clock because that's what's scheduled. But I just want to say that I'm very impressed with your background. I like your age. I like your age. I like your qualifications. I like your experience. And I'll tell you why age is so important. You bring life experience. 40-year-olds don't do any pro bono. They don't for any of those done. And we had a 40-year-old, I voted no last month. He had 2 jobs coming out of law school. One was, I'm glad you're sitting, one of 13 assistant solicitors in City Hall. And then he worked in the sheriff's office. I said to him at the hearing, did you ever think of applying for clerk magistrate? He said, I did. I said, but you didn't put it in the questionnaire. That's required. Oh, I didn't think that was judiciary. He doesn't know that there's a clerk magistrate in the court, that the clerk magistrate is appointed by the governor's council. I mean, did he think it was janitorial? I mean, this is what I'm saying. When I'm voting for someone to be on that bench, I want them to be qualified. I want them to understand justice in the judicial system. And it didn't hurt his father was a judge. I would never be biased against someone who had a father for a judge. But I wasn't biased against him. And they sent him to, and you know this, people know, a court that has criminal cases. Worcester. He never thought a criminal case, well, he doesn't have the experience. So that's what we're doing. We're putting in the court. And I've been the one here saying no. So I'm not going to be voted miscongeniality. That's why I'm on. So, I have to know I'm doing the right thing. And I don't find joy when I vote no, because I know it's the right thing. I know it's the right thing. Because I've met with them, I've investigated, talked to people, and when I make that vote. So I can say how pleased I am with you, and thank you for taking the ride. And the Belgian waffles, that wasn't it?
Thank you, Marilyn.
You'd have to take your daughter, at least, or your wife, to have the Belgian waffle, even though it is a long ride. Well, thank you so much, and I guess we'll wrap it up now. I'm done.
I'm declaring this hearing is over. We are adjourned. Thank you.
Nice to see you again. Always bring a different perspective on it, I like. All right?
Congratulations.
Hard work.
It's a gift.
It's hard work. I know.
Hello, Council. Would you like me at a specific time? Do you want me to log on or stay on?
I think you should stay on. I'm not running the meeting. Counselor Devaney is, but she's not back yet.
Very good. I'll mute myself. Thank you.
Okay, and I'm gonna mute me too. Bye.
Welcome, everybody. My name is Marilyn Pettito Devaney, and I will be presiding over this hearing. And I will read the letter from the governor. Dear councilors, I am pleased to nominate Christine Anthony to the position of Associate Justice of the Probate and Family Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. And I want to welcome you, and I will, we are going to start at 1:05. I was here to a hearing up till 1, so I went to the ladies' room, and here I am. So anyway, I'd like to introduce the councilors, Councilor DePalo, Councilor Kennedy, Councilor Duff, Councilor Ferriera, Councilor Jubinville. So first of all, I would.
Council Hurley's on Zoom too.
Oh, okay, she's down. Put her up. And Councilor Hurley is on Zoom. And first of all, I want to ask anyone who's going to speak and the nominee to stand. Okay. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you very much. Okay, I'm going to start with your witnesses. And you have the Honorable Susan. Okay. I'm going to say Richie. Okay, and you know, so many don't know. You can sit right over here. So many don't know. I don't know Italian, but I know my mother was a Danucci, and 2 C's are a cha. And we grew up with the Richies from Watertown, and they said Ricky. And then Lorena married one of the boys and says it's Richie. Something. So anyway, so that's a little vocabulary lesson. So welcome.
Thank you.
Come, Judge.
Thank you. Good afternoon, honorable councilors. It's humbling to walk into the State House and to appear before all of you today. The important and necessary work that you do in approving judicial nominees ensures that the citizens of the Commonwealth get the most exemplary and the most excellent judges that the citizens need and that the citizens deserve. As a former probate and family court judge, I thank you for your dedication and your service in this process. My first appearance before the Governor's Council was in April of 1993, some 28 plus years ago, my first confirmation hearing. To say that I was nervous is an understatement. Even a little nervous today. I have since returned to testify here when I went from a circuit probate to a Worcester probate and family court judge, and several times I have returned to testify on behalf of wonderful colleagues who have been approved. There's no amount of law school success, and there is no amount of law practice experience that can prepare you, Christine, for the thoughtful and difficult questions. But that is the necessity, and that is the foundation of this important process. These public hearings ensure that the judicial nominee is vetted and meets the highest standards. Today, I ask that you consider this and critical importance of the probate and family court bench. Of course, every trial court is eminently important to our citizens, but no other trial court requires the same judicial temperament, demeanor, and patience from its judges who day in, day out deal with litigants' pain, their anger, their hurt, their betrayal, their suffering, their addictions, their mental health issues, and the losses that happen in the family. Losses of their home, losses of their children, losses of their income and their assets. Probate family court decisions do not merely affect the litigants hearing in front of the judge, but decisions affect their children, parents, the grandparents, extended family, the new partner, etc. Families have to live differently after they receive the probate and family court decision. Still must go on and function as a family in the future. Probate and family court decisions aren't one-time commercial business decisions. They're not one-time accident or negligent recovery decisions or criminal punishment decisions. Probate and family court judicial decisions are personal family relationship decisions. The litigants have lived together as parents or as spouses or as partners or as children or as siblings. And usually they need to continue to interact after their decision comes down. These are the reasons that require that you, the Governor's Council, carefully and thoroughly reflect on each probate and family court nominee, which I know that you do. Appearing today for Christine Anthony is a pleasure and it's an honor. It is easy to speak favorably and enthusiastically about her because of her breadth of experience that she has that no other probate and family court judge that I know possesses. I feel that I have shared in each of Christine's legal endeavors since she graduated from law school. We began our professional relationship. I was a 3-year judge in 1996, excuse me, and she was my law clerk. I'm not ashamed or embarrassed to say that she was much smarter than me then, and she still is one of the smartest lawyers that I have ever met or worked with. Christine helped me draft my 1996 surrogacy decision and findings in an area when there was no law and there was no precedent. At that time, the Chief Justice, you only served as a law clerk for 1 year. And the Chief Justice would then choose one of the first-year law clerks to be his Chief Justice. It was Chief Justice Dunphy at the time. And the Chief Law Clerk, the second year, would work in the Chief's office and administer the 25 law clerks. I think there were 25 or 26 in the good old days when we had so many law clerks, and also work for the Chief Justice. Christine easily got and handled that position beautifully. The trial court judges, all 48 of us, knew that we could call her with our questions and our issues, and that she would promptly and correctly answer our concerns. She also taught and addressed the judges at our semi-annual conferences about all updates in the law. She interacted with all 48 of us seamlessly and respectfully, and that was only 2 years out of law school. After her law clerkship, Christine was hired by Lee, Levine, and Bowser, and now the premier family law firm in Boston. Their clients have unique and important legal claims, and their clients expect a lot. I personally know the 3 partners and associates there all loved working with her. They still refer her cases. She remains very close professionally and personally with them. Christine left private practice in Boston when she and Eric's family was very young. Fortunately for me, she returned to the Worcester Probate and Family Court as an assistant judicial case manager. She was hired by the first justice and served as his assistant. However, that is not to say that the other 5, because there were 6 probate and family court judges in Worcester, didn't constantly call upon Christine to assist us with our cases and workload. She assembled appeals, she reviewed pleadings for judicial approval, she researched and drafted decisions, and she was known as the go-to lawyer that not only the judges relied upon, but the bar relied upon for correct answers and help. Christine and I worked together every day for her 5 years as a judicial case manager, and she clearly made me a much better judge. Since 2005, Christine has been in private practice. Until I retired in 2014, Christine appeared in front of me, sometimes weekly, on divorce matters, paternity matters, child custody jurisdiction matters, removal matters, guardianship of mentally ill, conservatorships, and equity litigation. She is always prepared. She is always respectful to the bench, to the clerks, to the probation department, to the staff, and to the bar. She is often hired by trial counsel, other trial counsel to handle their appellate litigation. Christine has served, and this is incredibly important to the bench, as a guardian ad litem in both family law matters, mostly custody, and also in probate matters, where the incapacitated person suffers from a mental illness or a mental disability. Most guardians ad litem don't have that breadth of experience, or lawyers, both the probate side and the family law side, and she is unique. I certainly did not have it when I went on the bench. She brings experience on the probate side, which is the wills and estates, but an awfully lot of mental illness cases. And she also on the family law side. No other judicial candidate has this wealth and breadth of experience. Outside of lawyering, Christine and Eric have raised 2 amazing and kind sons, Eli and Rafi, who are both now in college. Seen her juggle her practice and her parenting. She always volunteered and participated in her boys' lives as well as legal organizations. She should be very proud of the parent that she is, and she should be very proud of the spouse that she is. In closing, I repeat that I'm honored to be here to speak in favor of Christine's confirmation. It's really a very easy and pleasant task for me. There's no more qualified and experienced nominee. As you carefully consider her qualifications, you can confidently know Christine will always do what is right, and Christine will always do what is just. Thank you for your time and consideration today.
Thank you very much. Any questions? First of all, let me introduce the council. Councilor DePalo, Councilor Kennedy, Councilor Duff, Councilor Ferriera, Councilor Jubinville. And is there any questions?
Thank you very much.
Questions? Thank you very much.
Feel that part of the speak. Much on the.
The next.
Don't sue me, Kate. The campaign's bill.
Okay, Madam Chairman. That's a tough act to follow. I'm not sure. How else I can
Say ditto.
No, I was thinking ditto would.
With that.
I bet. My perspective is different than a former employer or somebody who works employee. My perspective is a person who's going to carry a bag in the probate and family court and appear before this candidate. My perspective is, and I concur with Judge Rickey, the temperament is vitally important in the probate and family court. I won't regurgitate what
Judge Ricky said, but there was a judge in the probate court who had a great line. And people who come to the probate court for a divorce are generally good people on their worst behavior. And the criminals that go to court are generally bad people on their best behavior. Real true. It's
good.
Judge Sweeney. And I listened to Judge Ricky talk about the litigants that will come before Christine. And undoubtedly, a good probate and family court judge needs to have that temperament, because these people can find themselves on their very worst behavior. And there's no doubt in my mind that Christine possesses that temperament. Her demeanor since I've met her back she worked for Camille Saroof Sr. all the way through, whether she was at Lee and Levine, whether she was in the probate court solo, always has maintained a calm and pleasing, quiet demeanor. What is needed in the probate court with these people? Christine's legal acumen is unmatched. Truly, it's unmatched. I was talking to Counsel Jubinville outside, and in the district court, you could nominate a former prosecutor who has zero civil experience. And then she or he has to get up to speed to the detriment of the litigants in the district court. You don't have that problem here, because Christine possesses the mental health side, the estate side, and the side. Keeps her apprised and abreast of the changes in the laws that they come down from our SJC and our Massachusetts Court of Appeals. She is a tremendous candidate. She will be a strong candidate to the bench. We need it. We truly need it. I've been arguing for years that we get more probate and family court judges than we presently have, at least from Worcester in, to help the load. Christine Anthony is the easiest pick for this council this year, guaranteed. I can tell you, I wholeheartedly, without any hesitation, was her candidacy to the probate and family court bench. She will be a pleasure to try in front of. It's important for judges not only to understand, mention about the estates, divorce, you have to understand evidence. And there are complex issues of evidence that we deal with at Atwood and Cherney, that we deal with at Lee and Rivers and at McGrath and Kane. Valuation issues, understanding valuations, understanding evidence, how to get evidence in and keep evidence out. And as someone who has tried cases in the probate and family court, she has a very defined knowledge of evidence. I remember listening to Judge Ricky. I remember being one of those lawyers that would call out to Worcester, ask for Christine, say, can I just run this? The knowledge level is next to none. So I thank you for your time. I would suggest to each and every one of you, this is the easiest vote of the year. And I look forward to approaching the bench before Justice Anthony Probate and Family Court. Thank you for your time.
Give her just, wait, questions? Any questions? No questions. Now, how long have you known the nominee?
That goes back to the 90s, to the early, so Camille Saroof Jr. and I, who was just appointed by your counsel to the Superior Court, worked together in the Middlesex DA's office, and we had to tolerate Counselor Kennedy, very young, and he took advantage of us, and I still hold a grudge against him today. But he also did work at his dad's office, and that was in the 96, yeah. So all the way back to that. Now, we became much closer when I left the DA's office and Christine came into the probate and family court world. Well, when that was 97, and she showed me around. And she also worked for Steve Lander, who used to work with us. It's a very tight-knit group in the probate and family court bar.
Well, your testimony means a lot to me because you know her for all those years, so you know professionally and personally. And I've said it before, we've had people sitting there as a witness, and I've asked, how do you know, the nominee? Oh, I saw him once in court once, so I mean, that's not good enough, but yes, great, really.
The depth of our relationship is very deep, and I wouldn't be here if I wasn't fully behind her, and I am 1,000% behind Christine.
It's a tribute to her. Thank you very much for your testimony. Appreciate it. Next, we have Joseph Sacco.
WebEx.
Oh, I didn't know. Okay. You're on, Joe.
Thank you, Counselor. Good afternoon. And thank you for the opportunity to let me testify on behalf of Attorney Anthony as an Associate Justice in the Probate and Family Court. My name is Joseph Sacco, and for the last 24 years, I've been a court officer at the Worcester Trial Court. The first 18 years I spent in the Probate and Family Court, 14 of them with Judge Ricky. You were wonderful today, so I cut my speech in half after listening to you, Judge Ricky. And in the last 6 years, I've got to work with the grand jury. I impanel the grand jury, and I sit with them during their 3-month impanelment. I first met Attorney Anthony when she was assigned to the Worcester Probate and Family Court as a law clerk and during her 3-month rotation. I was immediately impressed with her. She was enthusiastic in her interest in the cases that came in front of the court. All the judges, she immediately got all the judges' respect. She returned in 2000 as an assistant judicial case manager. I observed her interacting daily with judges, lawyers, and pro se litigants. She treated everyone that walked into that registry with dignity and respect. Initially, I did not get to know her beyond her professional role. Every day, she would spend her lunch hour across the street with her oldest boy, who was in the daycare center there. After that, she had to take a short leave of absence because that boy had to have heart surgery. I was so pleased with his recovery and when she came back to the court. Shortly thereafter, her son entered the preschool. My son was in the 1st grade. She joined our little brown bag lunch group, and she sat with the court officers, probation officers, and judicial staff, and we would have our lunch together. And that's when we learned about each other's families, hobbies, and interests. We all were impressed with Attorney Anthony, her knowledge of the law, willingness to help people in the court. And one example of her willingness to help was back in the early 2000s in the old courthouse in Worcester. We were short-handed with interpreters. And every time we needed an interpreter to come in front of the court, the Department of Revenue, excuse me, guardianship cases, we went to Attorney Anthony, and she was more than willing to help interpret those cases. And she was respectful, friendly to all the court or people that came in front of her. When she left in 2005, it was a huge loss to the court. It was evident from the onset that she was going to be a successful private practice attorney. She was always well prepared, a fierce advocate for her clients, while being respectful to all the court staff, the judges, and to anyone that walked into that courthouse. Well, our friendship continued after she left the court. I had the pleasure of coaching both of her sons in flag football and watch each of them pass through the courthouse as summer interns. I know her to be caring, compassionate, and I've worked with many judges in 24 years in the court. And I know Attorney Anthony's knowledge, temperament, and ability to form relationships with the court staff. I am so confident that she will be a qualified, compassionate judge in the Probate and Family Court. I want to thank all of you for letting me testify today on behalf of Attorney Anthony and answer any questions you have.
Thank you very much. Any questions? No.
Thank you.
Thank you very much. I appreciate your testimony. I just wanted to say that first of all, I want to apologize. I thought you were here. I was looking for you in the room. So anyway, how long have you known the nominee?
I've known Attorney Anthony since when she did her 3-month rotation back, I think it was 97 and 98 in the courthouse.
Wow. Wow, that's quite a tenure. So you know the personal and the professional in the person,
I do.
right?
Yes. Absolutely.
Yeah.
I know her husband. Excuse me?
Could you think of one adjective that you could use for her qualifications for her as a person?
She has a fantastic temperament for the court. I think that I've witnessed many lawyers that come in front of the court, and her demeanor, the way she advocates for her clients, there's not too many people who've done what she's done and that came in front of the Probate and Family Court.
And you've seen some people along the way, right?
I've seen many people along the way, Counselor.
Right. Well, thank you. Your testimony means a lot to us. Thank you.
Thank you.
And that completes our witness list. Is there anyone here that's not on the list that would like to say something about the nominee? Okay. And I do want to say, before I call on you, that we have talked, and everyone that's in this council chamber has been vaccinated. We're very careful, and we've been very fortunate. We're the only body that has met all through the pandemic, so I'm very proud of the Governor's Council for that. So first of all, welcome, and I'd like you to introduce your family and your guests.
Thank you. Good afternoon. Today with me is my dad, Dr. George Anthony, my husband, Eric Richmond, of course, Judge Ricky, and my two dear friends and colleagues, Mary Jo Hart, Attorney Mary Jo Hart, and Attorney Aaron Shapiro.
Welcome. It doesn't have anything to do with your position, but I'm just so impressed on your husband's occupation. I love animals, and to be involved with the animals, I think that's really a wonderful profession. So now it's your turn. Well, is there anyone here in opposition? Hearing none, now it's your turn for your presentation.
Good afternoon. I would first like to extend my gratitude to Governor Baker for nominating me, and to Lieutenant Governor Polito, Chief Legal Counsel Bob Ross, Deputy Legal Counsel Lauren Green-Patrigno and their staff, and all of the members of the Judicial Nominating Commission for their time and guidance throughout this process. I'd like to thank Counselor Devaney hosting my hearing today. She too has been very helpful in navigating this process. I would like to thank all of the counselors for speaking with me and giving due consideration to my application. Thank you to my witnesses, retired Judge Susan Rickey of the Probate Court, Attorney Marty Kane, and Joseph Sacco. I am humbled to be here today to be considered by you for the position of Associate Justice of the Probate and Family Court. I would like to take this opportunity to share my background with you and what has led me to seek this position. I have spent the past 25 years working for and in the probate court. It is where I began my legal career, first as a law clerk and chief law clerk, and then as an assistant judicial case manager in the Worcester Probate Court. In addition to holding those positions in the court, I have been in private practice for 17 years, focusing exclusively in the area of probate and family law. Growing up, I never thought I would become a lawyer. Never knew a lawyer. My parents came from working class immigrant families and both chose public service for their careers. My paternal grandfather fled Greece in the midst of the Balkan Wars in the 1930s and arrived in this country with little education or money and did not speak English. My grandmother grew up on a farm in New Portland, Maine, and made her way to Boston, where my grandparents met and married during World War II. In 1955, the family moved to Brockton, where my grandfather worked for Howard Johnson's developing frozen food, and where my grandmother later worked as a CNA at the VA hospital, also in Brockton. My mom grew up in Needham. Her father was Italian and her mother was the orphan of Swedish immigrants. My maternal grandfather, though lacking formal education, rose to be the town engineer of Needham. My grandmother was the kitchen manager at St. Joseph's Church and School, also in Needham. My parents met their freshman year at Boston College and spent the next 59 years together until my mother's death this past June. After graduating from college, they started a family and within 5 years had 4 little girls. We quickly outgrew our apartment in a triple-decker in Brockton and settled in Sharon, where my sisters and I grew up. My father began teaching history at Sharon High School in 1966, the year I was born. He taught high school by day and attended Northeastern at night to earn his master's degree in education. He later earned his doctorate in educational administration, attending classes on the weekends and summers, all while he continued teaching. In the later years of his career, he was a high school assistant principal and principal. He kept a watchful eyes on his daughters as we made our way through Sharon High School. My mom worked a variety of jobs, including teaching, as she raised me and my 3 sisters. She worked for many years at the IRS in the Taxpayer Advocate's Office. She was strong, intelligent, and opinionated. Always respectful of the opinions of others, she was never judgmental and never sought to impose her views on others. Both of my parents valued education, hard work, and new experiences that would broaden our view of the world. They often added to our busy house by hosting foreign exchange students. Because of this, my primary goal in high school was to participate in a foreign exchange program. I spent my junior year of high school living with a family in Colombia in a Rotary Club. It was there that I learned to speak Spanish. I knew that the financial resources were not available to my parents to pay for college. I attended UMass Amherst and worked to put myself through college. I studied for 2 semesters abroad, one in Spain and one in Colombia. While at UMass, I met my husband. After graduating, I worked for 4 years in a shelter for homeless families in Framingham. It was that experience that I knew I wanted to help families in crisis. I attended Suffolk University Law School at night, while my husband attended Boston University School of Social Work. We both worked full-time to put ourselves through our respective graduate programs. We will celebrate our 30th wedding anniversary in a few months. We have 2 wonderful sons who are each over 1,200 miles away at their respective colleges. They have brought love, laughter, and adventure to our lives. We are proud that they are embracing the opportunities they have and are successfully navigating the disruptions in their education due to COVID. I am grateful that my dad is here today. When I told him of the governor's nomination, he congratulated me and said, "You always accomplish what you put your mind to." My sisters have been a constant in my life. We were so close in age and did everything together growing up. We were always simply known collectively as the Anthony girls. My youngest sister, Mary, has been my paralegal for 16 years. My family acutely feels the recent loss of my mother. We are learning that we can hold grief and sadness in one hand and gratitude and hope in the other. Know that she is here with us today. Throughout my career, I have carried with me the early lessons taught to me by the talented lawyers and dedicated judges for whom I worked. They taught me the importance of preparation and of knowing the law and applicable rules, the importance of professionalism and civility, and perhaps, above all else, they instilled in me the belief that a lawyer's reputation for truthfulness and candor is of utmost importance. Counselors, I humbly suggest to you that I have the temperament, skills, substantive knowledge of the law and procedure, and the experience to serve the citizens of the Commonwealth as a justice of the Probate and Family Court. I commit to you that if I am confirmed, I will listen carefully to the people who appear before me and bring diligence, patience, and compassion to the position each day. Thank you for your time and attention. I ask respectfully for your support and your vote. I'm happy to answer any questions that you may have for me.
Thank you very much. Let me start with, over here with you.
Thank you. Good afternoon.
Councilor DePalo.
This isn't my practice area, but let me ask you a couple of questions that will give some insight into how you approach things. So I'm hearing about the work you've done that gives you some empathy and compassion for folks who are struggling. And I heard comment from your witness that we often see good people at their worst moments who might be appearing before you. So could I count on you to have a very high bar for holding anyone in contempt? And what would that bar look like?
I do think that contempt actions are brought very frequently in the probate court, and we do need to make a finding of a clear and unequivocal order and an equal and unequivocal disobedience. I would enforce the orders as they've written, and the other part of that is a request for attorney's fees I would grant if I find a person to be in contempt.
I suppose I'm more wondering about managing the courtroom, folks who are in the courtroom before you.
Need a complaint for contempt?
From the bench.
Yes. process. So I think my answer to you would be that I would hold people in contempt, and I don't think is particularly high. It is there a clear and unequivocal order and an equally clear and unequivocal disobedience?
What, we've heard about your knowledge of mental health and your experience with issues around it. What do you see as being challenges that the Probate and Family Court are dealing with right now? How does a probate or family court judge address issues?
With respect to mental health specifically? So we see that very often when there's an allegation that a parent is unable to care for a child due to mental health issues. And as the judge, I think it's important to monitor that, of course, to ensure the health and safety of a child who may be impaired as mental health issues. So part of monitoring that, we have status conferences to be sure that that parent, for example, is complying with the treatment protocol and the regimen that has been suggested for that person.
And when it comes to matters of custody, besides the safety of the child, which is obviously paramount, what kinds of considerations would be persuasive to you in terms of modifying custody arrangements?
When it comes to modifying a custody arrangement, what we're looking for is a change in circumstances and that the change proposed is in the child's best interest. So we use that language, the best interest of the child, and that encompasses a lot of different issues, including, for example, is the child in school? Is the school appropriate? Or is the child receiving the medical care or the mental health care that the child may need, et cetera?
I've heard my colleagues on the council asking about experiences with travel distance between parents and whether or not that should impact custody arrangements, or what the threshold is for them. How far away does it have to be before a judge would approve modifying custody interest of the child? What do you think about
Instances within the Commonwealth?
correct?
So I'm a proponent, of course, that parents have equal access to their children. And sometimes people live far away. And I think the real question is how can we accommodate that? And more often than not, particularly if you have two willing parents, you can accommodate quite a distance. I would just want to be sure that both parties have the ability to participate in that transportation.
What if one parent is suggesting that the travel time to the other parent is not in the best interest of the child? So they're seeking to modify the custody.
I don't think I would be so persuaded if that's the only issue. Of course, we could talk about different factual scenarios. Perhaps a child has special needs. Perhaps a child has ADHD. There could be some problems where that is a legitimate concern. But in general, I think it's important to promote a relationship with both parents for the child. And sometimes parents live far away, and sometimes there's going to be traveling involved.
Thank you. I don't have any further questions for you now. I look forward to having a chance to talk with you. It's entirely on my accord that we weren't able to talk prior to this hearing. I appreciate your answers to the questions. Thank you.
Councilor Duff. Thank you, Madam Chair. Great to see you. Thank you for applying. Thank you for applying to this court, which desperately is one person we know said it's a big functional family. It has its challenges. Some of those I think are more managerial than anything else, as I talked to you about. As you know, from your studies and everything, there are several issues that are most important to me as one of them. I know you have a lot of background in substance abuse. Fortunately, this is something that's almost epidemic right now in the courts, maybe not in the state, but in the courts. And so I think your 4 years previous to the law studies have probably served you very well. I feel good. I actually am confident in all these issues with you, even though we covered them in detail when we spoke. The other issue is, and I see you do work the work you do with the ARC, is that like the ARC of Massachusetts?
That's attorneys representing children, so it's a volunteer.
What I wasn't sure of. Very active in the ARC of Massachusetts, which is special people, special needs people. That is an issue that's personal to me, as I had a special needs sister. And I feel that, you know, the probate court, I think it's differently than maybe a district court, but really special people have special needs, and not just in accommodation in the courtroom, but in how they are treated. Can you?
Are you referring to a litigant or a party who might have special needs?
Question, either a litigant or a party or a special, you know, involved in a, you know, maybe a contentious divorce or something like that.
I think that's more frequently where we would see that. And so when we have a custody dispute, for example, with a child who has special needs, perhaps on the autism spectrum, I think it's important that potentially there is an ARC attorney appointed for that child if the child is a little bit older. In addition to that, guardian ad litem would be important. We needed to investigate and have some information reported back to the court about whether or not those child's needs were being met by one or both of the parents.
Good. You know, I feel strongly, I don't have any children, but I feel strongly that as elected officials, as people in the courts, you know, we as adults, we're responsible for kids, and we should and need to be held to a higher standard. And in probate court, you can have a direct impact on parents and children's relationships, safe, unsafe, equitable. I mean, it's a plethora of things. It's work. So I really applaud you to even apply for this. I'll digress from the last issue I want to talk about, but the one thing that is important to me, and we did talk about it a little bit earlier, in all of our courts, but in a court like this, I think there is a tremendous amount of emotional and spiritual stress that gets put on judges sometimes. Today, our judges are asked to be, you know, priest, rabbi, teacher, social worker, nurse, doctor, all these things. You are dealing with some really tough issues in probate. Do you, and this is not a trick question, it only answers to the with this. To think about it. Do you feel that you have a strong support system that can hold you up in times of stress, and that days that might be of distress to you? Witnessing and seeing horrific things, because you will.
I think being a divorce litigator for 17 years has prepared for that, because we see those same things in our private practice. And in some ways, it can be harder because remember, they have, and so I think engaging that type of litigation has prepared me for the role. But as I look around the room, I see my support system. They're sitting against the
marriages.
And so I have had that network. I think it's the only way you can succeed in private practice as a divorce lawyer.
Yeah, I just think I think it's a real tough thing that we don't talk about what judges are subjected to today. We live in not just a litigious society, but in a contentious society where if you do something that's unpopular or maybe turns out to be different than what you expect, all the onus, all the blame gets piled on you. And sometimes there are dire consequences that no one wants to do the wrong thing. No one wants the wrong outcome, but it's something that I think as governance counselors and practicing the judiciary, I think we need to be acutely aware of it. of this, and I'm a chaplain, so I see some of the spiritual distress of at you. That's an intangible thing that's tough. So I'm glad, I suspected, just knowing about this fella, that you probably have a good underestimated. Okay, so the last group of folk that I am always vocal about are people who are in the LGBTQI community, gay, lesbian, transgender, whatever. We have equal marriage in this country still, and hopefully forever in the state. So you're dealing with different issues than maybe we dealt with 20 years ago. Have you had experience in any litigation with parties in this group? And do you feel comfortable that you can be fair and open-minded? So stay out of judgment. Have you any experience working with folks in the transgender community? Yes. That is really important. Of all of these, everyone's really important, okay? Every person in the Commonwealth is, but any disenfranchised group is important, again, as I said, for us as the adults in the room, as the electeds, to stand up for and defend and recognize it. Somebody of something that they've done that may not be right or incorrect, as someone said, see them on the first day of their life. But to be able to know, to use, and that we don't understand everything. You know, some of this stuff is really, really tough. It's real. Because of that, it's in futures in your hands. And so knowing that deep compassion or empathy, I don't know that empathy would be the right word, but openness to learning is important. I think our justices are doing a great job leading in this particular area. Our chiefs, they've done a lot of work on it. You came with a recommendation from a sitting judge who I have respect for. I'm not an attorney, so I don't hear from a lot of the lawyers and everything all the time. Judges know how I feel about it, and they know what things mean than others. And so when someone reaches out to me and says, "This is a good one," mention Duff, I do, and I'm glad that you've applied. I think I admire your courage for entering this this coliseum you were asking to enter, and Godspeed to you. Thank you, Madam Chair.
No, thank you very much. There's only two councils here to ask. Is Mary still here? Zoom?
Yes.
Mary, I don't see you.
To be able to hear her.
I'm here.
Okay, good. Okay. Mary presided at the last hearing, so Mary and I had 5 minutes before this hearing to run to the ladies' room, not to eat. So how you doing, Mary?
Okay. I don't have a lot of questions. Because of my background in being a judge and also on the Governor's Council, I have a network of judges all over the state that I can contact concerning different nominees for different jobs in terms of the justices and the clerks. I would indicate that I did speak to the nominee. We had a great conversation. I would further indicate that before I spoke to her, I called some of the people in the Worcester area who sat on the bench, and the recommendations that they gave her were glowing. She's phenomenal. She's always prepared. She's polite. She's courteous. She's thoughtful about everything you could imagine under the sun. So I really don't have any questions. I think she's going to do a great job, and I'll be voting for her. So
Oh,
thank you.
thank you, Mary. No, I think Mary and I share the same thing that, you know, personal life experience is important to bring to the court, and you have it. And I think that's what Mary looks for and I look for too. What I like was that you did work in the court, in the probate court, you know, so you have this experience. How do you think that helped you to understand the workings of the court, that you've had those two positions, what was it, 3 years or whatever it was before?
When you've worked in the court, you understand how the work flows. So as a lawyer, when you walk into the courtroom, you see the judge on the bench with a file in front of her, but you don't really know how it is that file actually got to be in front of the judge. And also how the file is organized and the types of things that you need to be able to find in the file to be able to process what's before you quickly and then be able to hear the case in a reasonable way. So I think having the behind the scenes work will be me, that knowledge.
Well, what I liked was when you said how you're going to work with people. And we don't often see that in when they're answering the greatest challenge of the court that you're going to. And you said that I would work closely with the staff assigned to me, including the sessions clerk, assistant judicial case manager, law clerk, probation officer, to run my session as effectively as possible. Okay, I think that's very important, you know, that I want someone who works, not looking down, but working with the people in the courthouse. And that's what impressed me. The other thing that I see in you is that to decide to be a judge, you said that it was really, you know, it was a process that you got through to decide. 55, that's wonderful. I don't want 40 years old, you know what I mean? And so that's the thing, you bringing your experience in, you know, to the position. You know, that's so important. And you know what that I liked about you? And I haven't seen this in the questionnaire. What you saw was the greatest challenge. And you say, access to justice for pro se litigants. And, you know, I can't even imagine how difficult that must be for someone who can't afford a lawyer, who's going into court. And for you to care, and you have said it's a long-standing problem. And, you know, so tell me, how will you plan to meet that challenge?
Of the pro se litigants. So I do think that it's important that every step of the way when a person comes into the courthouse, that he or she is able to be attended to in an appropriate way. So when starting in the registry with the registry staff, with the correct paperwork, with the correct filings, when that person does finally make it into the courtroom, it's important, if the person needs an interpreter, that we have an interpreter present, that the paperwork is filled out correctly, and if it's not, to help have the probation department help us make sure that that paperwork is complete so that we can hear the case in an expedited manner.
And you know, and you're very sensitive to they don't have access to transportation and can't take off from work and fear of losing their job, or maybe they have mental health issues. You're bringing all this in that I think that I know that Councilor Duff is concerned about that. We're concerned about mental health issues, and a judge is really up on that to understand. And what will you do, you know, when you do have someone with mental issues? The other thing is, it's so valuable. You speak Spanish. I mean, you know, in today's society, that's so important to have a judge there, because I'm sure that there isn't always available someone to communicate or interpret. I don't know, especially with this pandemic, it must have really got worse, you know? So, so what would you say about you know, about that, as far as how much authority do you have as a judge when you have someone and you know they're worried about they'll lose their job if they come to court and everything? What kind of things can you do?
We could continue with our Zoom hearings. There are some times when a telephonic hearing might be appropriate. Do think we can accommodate schedules, or perhaps they need a 2:00 hearing. They work in vice versa. So I think there are ways that we can accommodate people's schedules.
What is your position in joint custody? You've been involved in that. Tell me some of the cases and how it's worked out.
So I believe that parents should have equal access to their children, and children should have equal access to their parents. I've litigated a number of those cases seeking shared physical custody, shared legal custody. Those are difficult cases. Oftentimes there's a guardian ad litem involved or attorneys appointed for the child. But for most people who are seeking equal parenting time, that fight is worth it for them.
One of the, in your question, I just didn't get it. Maybe you can explain it. The father had the child from Tuesday to Sunday, and the mother had Sunday to Tuesday. How is that joint custody?
In that particular case, that was related to the distance that the parties lived and where the child was going to school. So the way that that was arranged, and that was a judgment of the court, that the child spent the majority of his school time with the father, but then there was sort of, I won't call it makeup time, but there was more time for the mother on holidays and summer. So that if you looked at the year calendar, it came out to be more or less equal.
I'd like to talk about removal. I have brought this up before. This was the first year I was a governor's counselor and voted for someone on the probate court. And, I had that feeling, oh, I don't know, and I voted for her. But I had some apprehensions. And unfortunately, I don't know why, because I didn't have anything specific. She's a good person. She had some qualifications. Then I saw her in the Boston Globe, and this was like 2 or 3 years after she was a judge. And it talked about her decision in a removal case. She had a case where the father and mother were divorced, and they had 3 little close in age toddlers. And she was asking to move to Oregon with her 3 children. And the father had been very devoted, lived near, saw them almost every day. Even Christmas Eve, he'd stay overnight to see them Christmas morning. So anyway, she was asking to move to Oregon. What kind of criteria would you use to allow someone to remove the children?
In that particular situation, I would want to know what was the basis of her request to remove the children to Oregon. Had she remarried? Did she have a new job? Was her family there? Was there some reason why she needed to leave Massachusetts? I'm not hearing that any of those facts were present in that particular case, but in general, I would be thinking about what is in the children's best interest, and clearly maintaining a relationship with their father here would be of paramount importance to me when I'm considering what is in the children's best interest.
Well, in that case, and imagine it got in the paper, she had no job waiting. She didn't know anyone there. She didn't have family. She didn't have friends. She had nothing waiting for her. And to me, it was vindictive. I mean, now that poor father is actually divorced from his children. There's no way he's going to be able to communicate with them. So she gave him, I hate that word, visitation, right? 1 hour, 6 to 7 on the computer with the children. You can't hug a computer. I mean, I just couldn't believe that she did that. So I guess the point I'm making is I don't have a crystal ball. And I only, I vote on someone and you hope that they are what they appear to be. And sometimes they're not and they let you down. And she absolutely did. And I think of that poor father. I feel so bad for he and his children. And so I like your answer. I really like that. That's what I would want to hear. So what is your relationship between the Department of Children and Family? Do you work with them at all?
So CF, as we call them, occasionally they're involved in a case of mine. I don't have too many cases where DCF is involved, but certainly we do see those cases in the probate court.
Well, I'm not a fan of theirs. And you know, you can say, well, they're overworked, they got too many workers or whatever. But, you know, you don't even have to be an 8th grader. If you go into a home and you see a 7-year-old that's the weight of a year-old child, you know something's wrong. And they close these cases. I'll never forget the baby Bella. Mother lied, said she was sleeping or she was away and everything. And, you know, they had her in a bag and they threw her in the water. I mean, it just, those are the things that really bother me. And I don't know what happens. Does anyone make any changes? Do they change the department head or whatever? I don't know. But that really is a concern of mine, you know. So will you work with them closely as a judge?
As I said, there are a number of DCF cases that do come into the probate court. The majority of the cases where there's a care and protection and a child's in foster care are going to be found in the juvenile court. So we don't see them as frequently as we used to. When Judge Rickey was on the bench, the probate court did hear those cases, but as I say now, they're primarily in juvenile court.
See, that's the thing that bothers me, and I hate reading these stories because I can't sleep after I read them. And there was one recently that I read, and it was a young couple who had a 4-month-old baby. It was taken away because they were abusing the child. They sent it back and they killed him. How often does that happen? I mean, what kind of judgment is that? If someone does it once, isn't that once enough? I mean, give that child a life, you know? But that really concerns me. So I don't know whether how much recommendation you can make as a judge, you know, on a organization like that. I don't know, department. Do you have much influence as a judge?
Well, ultimately, it is up to the judge to oftentimes to approve of placement of a child. So there can be some influence on that process, but primarily that's going to occur in the juvenile court.
I'm interested in some of your writings, and I think that's wonderful that you write. I think that's so important. One of them was, what was it, psychological witness? What was that one? What was that about?
So we have, we call them the blue books, but they're, I think they're put out by MCLE, and they're on topics. And so over the years, I've written some chapters within that book. And one of the pieces that I wrote was about the use of guardian ad litems, and that was the psychological aspect of that particular chapter.
Now, you've been doing that for a while. Do you stay with that one child, or when you're, you know, a guardian ad litem?
When I'm appointed to be a guardian ad litem to investigate and report back to the court regarding a specific child, once I file my report, my role is over. Sometimes it gets resurrected. I have been the GAL on a case, on the same case at least twice, meaning some years have passed and then I'm asked to, something else happens and I'm asked to do another report.
The other thing is, I mean, if you're 15 years old and and you want to go to the school, that's such an important decision when you have divorced parents, that they really have to think what's best for the child, not what's more convenient for them and or whatever to get them there. And that was your writing about that 15-year-old boy, and I was very happy about the result. You want to talk about that?
So that was a case that I had tried some years earlier. It was a custody case. And my client worked at a private school, and the child had the opportunity to attend that private school. It's a very prestigious school. And mom was objecting to his attendance there. Her position was that he should attend public school. And so we filed a complaint for modification, and the judge appointed a guardian ad litem to investigate and report back on the issue of school. And ultimately, the child was able to enroll in school.
Yeah. And that's so important at that age too, because that, you know, they bond, their friendships and everything at that time, you know? So, so now, have you ever, kept in touch with these people that you were a guardian ad litem to see what's happened in their lives?
I've not kept in touch with anyone that I can think of where I served as a guardian ad litem. However, it's not unusual to hear what has happened through the lawyers who have represented the parties.
So you've been involved with children with learning disabilities and autism and mental issues. So in that position, do you recommend, you know, services for them? Tell me what you do.
So it would not be unusual if I'm asked to make recommendations as a guardian ad litem to set forth some things that I think should happen. So for example, perhaps the child needs to have an evaluation through the town. I might recommend that. Perhaps it's been told to me by the pediatrician that the child needs occupational therapy or needs speech therapy. I would make those recommendations, things of that nature.
Now, did 209As ever come up before you that are in violation, or is that not in that court?
Violations of the 209A would occur in the district court, generally, not in the probate court.
Okay, okay. Yeah, so tell me about some of your writings. There was another writing that I thought, yeah, but that one, psychological, but that, I still didn't understand that fully, what that person is that you're talking about.
I believe in that chapter, what we were talking about were the experts that you could use, like a GAL or a mental health professional, to act as an expert in a custody case.
There was a case that, you know, the thing is, when you read the JNC questionnaire, you don't know the rest of the story because you can't put the whole thing in. So can you tell me about that paternity case? And the father had 2 young children, and the mother died unexpectedly of a brain aneurysm. And so he was saying, this man came and said he was having an extramarital relationship with the client's wife. And so what happened?
So the gentleman who alleged that he was the biological father of the children filed a complaint in equity in the probate court to establish.
Does he have to establish his DNA first, or how do we do it?
DNA would come second. So the first thing that he has to prove under the case law is that he had a substantial relationship with the children before he could request the genetic marker test. So the trial that we had was about that narrow issue of whether or not he could prove to the court by, I believe, clear and convincing evidence that he had a substantial and material relationship with the child. He was unable to prove that.
He said he was father of both children, right?
He did.
So does the wife who died, does her family have any input in this, or how does that work out?
Particular case was just as between the 2 parties were the father, who was the legal father, and the gentleman who alleged he was the biological father.
So what happened to the children?
So the judge denied his request, and it went to the appeals court, and the appeals court affirmed the trial court's decision, and the children remained in the custody of their father.
Even if there's medical evidence that he is the father, he still would not get custody?
Well, the medical evidence would be the genetic marker test. And in order to reach the point of having a genetic marker test, you first need to get over this initial hurdle of proving to the court that you had a substantial and material relationship with the children.
You know, really, you're so qualified to even ask you any questions on these, you know, but now is there one divorce case that comes to mind that was really probably the most rewarding, or what was the most disappointing result?
I think for me, the most rewarding cases in general are typically when a person comes to me and feels it really is at their worst point, at the lowest point in their life, and they feel that they will never come out of this divorce as a whole person. And we worked together for a long time. Divorces take a long time. And it's gratifying for me to see the way in which a person can develop his or her self-confidence, see and see herself in a different way going out into the world. And when you come out on the back end of that, I think those are the gratifying cases.
The other thing is, it has nothing to do with this particular thing, but I just wanted to say that they're doing a redistricting because of the population shift. And I don't know what I'm losing and what I'm gaining, but I only know I'm losing Westboro. So you may be the last nominee from Westboro that I'll have the honor to preside. So I'm so happy it's you because I'm so pleased with your appointment. But yeah, I guess it's the district coming from the western part of the state has decreased, and mine has been stable and it's been increasing. So they have to shift, so I'm gonna lose something. I have no say about it, so I don't know what, but I only know Westboro, and I'm going, oh, like a knife in my heart, 21 years, because you make friendships, you know? But I can't tell you how pleased I am and how proud I am to be presiding over the hearing. It was a pleasure to meet with you for all that time, and I know your boys would love the Belgian waffle. I know they would, not that your husband wouldn't, or your father.
We go back when they're home for Christmas.
No, you have to. But, so I'm going to adjourn now. You know, I'm just very pleased. And so next week, December 8th, when we have our public assembly with the Lieutenant Governor, I will present your name and we will vote. And so, I'm very happy. I really, you know what I'm happy about, that we have someone really, really qualified, because sometimes we miss the boat. And to me, and you said it to me when we met, and you said it in your questionnaire, it took a lot of time for you to think about, should I apply to be a judge, 55? That's really a lot of thought to make a decision like that. So I'm very pleased, really. Any more questions, Eileen? Are we done? Okay. So thank you very much, and how wonderful to have your father here, to be so proud. That's great.
Good luck to you. I know you'll do a great job.
Thank you, Counselor Hurley.
You bet. Take care.
Done, Mary.
Bye-bye.
That is the best. Congratulations that you were wonderful.
And I got a meeting tonight. It is.
I should have said.